Welcome again, everybody, to this quote-unquote last session of our hearing. I don't think there will be any housekeeping issues for the parties raised, so we can go straight into the direct presentation by our expert. First of all, could you both of you read out the declaration for experts you have in front of you?
Is there a difference if we press the left or the right button? Or it's the same for the, okay, perfect. Good morning, everybody. My name is...
No, sorry. I was saying first the statement.
Yes, but I was going to say my name.
Okay.
So my name is Rodrigo Zamora. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Buenos días.
Good morning. My name is Daniela Mesquita. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Okay, so as a minor reminder before you start talking, is please do not talk over each other, nor with responding to questions. So introduce a small pause so that the stenographers have an easier task. Other than that, sorry, Mr. Porter, I think, wants the floor.
Yes, they're just going to proceed with the presentation at the beginning, and then we'll ask questions in the redirect.
Mr. Zamora or Mr. Mesquita, go ahead.
Good morning, members of the Arbitral Tribunal. Good morning, representatives of the parties. Again, my name is Rodrigo Zamora Charren, together with my colleague Daniela Mesquita Diaz. We have been retained as experts on Mexican law. We have presented 2 expert reports analyzing some of the irregularities that took place in the proceedings related to contracts 803, 804, and 821. I will deal with the irregularities in the civil proceedings, and my colleague, Mr. Mesquita, will deal with irregularities in the administrative proceedings, because that is our practice for both of us. We have prepared this presentation in English. I am able to answer questions in both languages. I understand my colleague will address the tribunal and the questions in Spanish. Regarding some of the main elements of my curriculum, I am a lawyer with over 30 years of experience in civil and commercial litigation. I also participate as lawyer, as an arbitrator in proceedings before different arbitral institutions. I've been an expert in Mexican law in judicial and arbitral proceedings, including those cases, a couple of ICSID cases, which is Lion Mexico Consolidated, and another case, the BMEX LLC, and others, both of those cases against the United Mexican States. At Galicia Abogados, a Mexican law firm, I head the litigation practice, and I'm a co-head of the arbitration practice. I am admitted to practice both in Mexico and New York, and I was formerly very active in the Mexican Bar Association. I was a former general counsel and vice president of said bar. The way I'm going to present this is I have 2 slides for each of the 3 cases, one with the background and another with the main irregularities. If we go to the civil case 803, this is a case that was filed in October 2015 by Bissell Construcciones e Ingeniería and MWS Management. The claim was initially dismissed by the district court under the argument that the case was considered administrative. The appellate court, under an appeal filed by the claimants in that case, overturned that dismissal. Once Pemex was served with the claim, it filed a motion again to have the case considered as administrative. The district court accepted said motion, and after considering the merits of the motion, again granted Pemex the motion and again decided that the case was administrative. Claimants had to appeal that decision. The appeals court again vacated the decision, indicating that the case was not administrative but was a civil one. Against that decision, Pemex filed an amparo. That amparo in its 2 stages took until May 10, 2018, when the amparo was denied and the decision of the appeals court was affirmed. Afterwards, the proceedings started moving forward. There were some appeals and evidentiary issues which again suspended the proceedings close to 2020. And at the end, on March 22, 2021, claimants filed for the withdrawal of their claim, and no further action by claimants took place in that proceeding. Some of the main irregularities. First, the decision on civil versus administrative jurisdiction took from October 13, 2015 until May 10, 2018, almost 2.5 years, just to have a decision on whether the case was civil or administrative. Number two, the district court, upon Pemex's motion to have the case decided or be rendered as administrative, in my opinion, violated the prior ruling of the appeals court that had already decided that the elements of the claim made it be a civil and not an administrative one. And of course, all of that, again, gave rise to the appeals and the amparos that I have previously mentioned. Number three, again, the proceedings were suspended due to the appeals on evidence, which again carried on a delay in the decision in that case. And as a consequence of all of the above, as of March 22, 2021, which is, as I said, the date of the filing of the withdrawal, 5 years and 5 months had taken over, and still there had been no decision on the merits at the district court level, forget alone about appeals or amparos. Civil case 804, this was also a case filed by BSEL and MWS Management. This case was filed on December 8, 2015. Again, the district court dismissed the claim without a serving process on Pemex because it considered the case as administrative. The appellate court confirmed the dismissal in 2016, February 12 of 2016. It's interesting to note that in the judgment of that appeal, a reference is made to a filing made by Pemex, and I say it's interesting because Pemex by that time had not been served with those proceedings and should not have, or at least I don't have elements to know how they had access to the file and know what they had to file and in which court. Against that decision, the claimants filed an amparo, and the amparo was rejected or denied in October of 2016. Hence, the civil case ended with the dismissal of the amparo in 2016, almost a year after it was started. And again, after this year of civil litigation, the case was moved to the administrative courts, and that will be addressed by Mr. Amezquita. The irregularities in this case, again, the inadmissibility of the claim. The civil claim was never accepted nor served. There was absolutely no argument or discussion on the merits. The judgment considering the case as administrative was contradictory to what happened in cases 803 and 821. Number two, Pemex's appearance in the appeal. As I said before, the judgment makes reference to a submission filed by PEP in that appeal, and that was despite the fact that Pemex was not a party to that case yet. It had not been served. It was a case that had not been admitted. It had not been served process, and as far as I know, the district court's decision had not been made public, so it was making arguments to support a decision that, as far as I know, was not public. Number three, omission to supplement claimant's amparo claim. As I said, there was a dismissal by the district court that was appealed, and then there was an amparo. And the amparo rejected most of the arguments made by claimants on formalities without going into the merits of those arguments that were made in the amparo. My opinion is that the via, the way to present a claim, is one of the situations in which the amparo court should have supplemented the claim or should have analyzed the arguments made by claimants and not dismiss them on formalities. Finally, the civil case of Contract 821. This one was filed by Drake Finley, Finley Resources, and Drake Mesa against Pemex. The case was filed April 29, 2016. Pemex filed its response to the claim. In that answer or response, Pemex did not file any motion to either to consider the case as administrative or to request the referral to arbitration. And I make this last comment because the 821 contract that has been pointed out included an arbitration agreement. After the whole procedure took place, the district court on its own issued a judgment in November 8, 2017, referring the case to arbitration, even though none of the parties had requested such referral. There were appeals by the parties. The appellate court upheld the referral to arbitration on April 19, 2018. Afterwards, an amparo court vacated that decision and ordered the appeals court to assume jurisdiction and to decide. That was done in February 2019. Upon that decision, the appellate court assumed jurisdiction and on April 2, 2019, issued a final judgment declaring that claimants failed to prove their case. Claimants filed for withdrawal of their claims on March 19, 2021, and no action by claimants took place after such request. After the April 2, 2019 decision, there were further actions and amparos, mostly by Pemex, to insist on a pursual of costs against claimants, and that took place for some years. Two irregularities here. The first was the referral to arbitration. Again, none of the parties requested that referral. Claimants filed their case in the Mexican courts, and Pemex answered without requesting that referral. Mexican law does not authorize that referral on its own. Hence, the judgment that was entered by the district court was contradictory to that of litigations under 803 and 804 by making that referral to arbitration. And finally, the appellate court, the one which decided the merits of the case, was not the court that had received the evidence, as usually it is the case with the district court, and then there may be an appeal to the appeals court. But in this case, the decision on the merits was issued by a court which had not received the evidence presented by the parties, but it's only an appeal court that does not receive such evidence. That ends my summary. Of course, I remain to the questions that afterwards respondent will make, and of course to those of the arbitral tribunal. And I render the microphone to my colleague.
Thank you.
We're now going to talk about the irregularities that we found in connection with the administrative proceedings. The only thing that I want to point out in connection with my CV, which is something that is interesting for this arbitration, is that I have more than 30 years of experience in the administrative field in Mexico. I am a partner in charge of the administrative and constitutional practice in Galicia Abogados. In my professional experience, I have handled administrative cases and also the negotiation of finiquito, conciliations, also the challenge of administrative decisions, amongst other disputes. In the Mexican Bar Association and in the ANADE, I have been in charge of the Administrative Law Commission. Let us start with Contract 821. We do see there some peculiarities of this contract, and this has to do with the analysis that we are going to conduct. On 28 August 2017, the motion was issued ordering the termination of this contract because Work Order 28/2016 had not been complied with, and the order had not been signed, and also some breaches were alleged in connection with the non-performance of the PACMA program. On 4 September 2017, Finley, with other companies, filed a request for annulment before the Federal Administrative Court against the administrative termination. On October 4, 2018, the Administrative Court issued its final judgment indicating that the administrative termination was valid. and the companies filed a direct amparo, and this was upheld by the Federal Administrative Court. What is it that we found? Well, we found violations to three principles that are procedural in nature, administrative and procedural in nature. First, the principle of consistency. I'm sure that the arbitrators have dealt with this principle, the principle of consistency, and the principle of completeness. And also, there was a lack of motives and reasoning. Let us deal with these principles. At the administrative level, this was submitted by the claimant companies before the administrative court was decided by two of the chambers of this court. What we have found is that there were violations to these principles of consistency and completeness. Specifically, because they're included in Article 50 of the Federal Law of Administrative Procedures. And we're going to, of course, deal with this in connection with the questions posed by the parties and by the arbitral tribunal. Now, in connection with the principle of completeness, I'm sure that this is very important. This entails the complete analysis by the tribunal in connection with the matter put to it. Article 50 was violated by the tribunal when it issued its judgment because one of the main reasons for administrative termination was not examined in the manner that we think was the correct manner. To the best of my knowledge and belief, in connection with the ground for rescission, which was the noncompliance with Work Order 28/2016, we have to recall that the authority said that out of Clause 15.1 of the contract, they cited paragraph B and paragraph S. I'm going to leave paragraph B aside for a moment because this has to do with the fact that the representatives of the company should appear to receive the work order and to sign it for it to be carried out. But subsection S refers to the noncompliance with the work order and the noncompliance with PACMA. This according to the authorities. But subparagraph S is what we call in Mexico a catch-all. This has to include everything that is not established as grounds for rescission that is going to be put in there. To apply paragraph S, the tribunal should have done two fundamental things. First, this is a general ground, so it should have looked at the grounds, that is to say, the noncompliance with the work order, and that it should have seen as not included in subparagraphs A to R. Subparagraph S is not self-containing. It cannot be self-updated. I cannot really link paragraph S with another obligation included in another contract clause. In this case, the authority talked about subparagraph S in connection with clause 2 of the contract that establishes the purpose of the contract. But clause 2 does not talk about work orders. It only includes a general definition of the purpose of the contract. If we had conducted, or rather if the tribunal had conducted a profound analysis, as we have seen in other cases that are similar to this, the tribunal would have realized that the authorities and the tribunal there was another paragraph, paragraph R, that establishes specific situations for the noncompliance with work orders. 15 non-performances have to be accumulated for the grounds to become active, the grounds for termination, that is. In connection with the link between paragraph S and other clauses that entail a breach of the contract, I think the most specific one for work orders would have been 6.6, that specifically deals with what happens when a work order is not fulfilled. They should have done that instead of talking about something that is general and that does not talk about the work orders. Fulfillment of the work order meets the purpose of the contract, of course, but at clause 2, they only talk about the purpose of the contract in general and what activities are going to be carried out to meet that obligation. We think, for these reasons, that we think that the tribunal did not act properly when it dealt with this matter. The judgment is quite voluminous, and we have to look at an exhaustive analysis. First, everything that has to do with the non-performance of the PACMA, the alleged non-performance of the PACMA. When I look at this judgment, when mention is made of the PACMA, the tribunal could see the arguments from the claimant and from the authorities. It transcribes things, it mentions articles, it talks about the PACMA annex. Nobody asked the tribunal to do that, but it did so anyways. And then it reaches its conclusion in connection with the alleged non-performance with the PACMA. The other issue that is also addressed in the judgment only gave 3 or 4 pages to the issue of rescission. Well, the other matter is the way in which notice was given. The tribunal looks at this exhaustively. It talked about the way in which notice had to be given. I think this is clause 19 of the contract, as it talks about how these communications are to be made between the parties. The private party said that the law on procedure applies. The tribunal could have said, okay, these articles do not apply, and it talked about how things should be done in accordance with the clauses of the contract, but it introduces other elements that were important for the tribunal. For example, the use of logs for these types of communications, to include these types of communications. And they do this in 30 pages of the judgment. I do not agree with the conclusions by the tribunal, but there is an effort by the tribunal to meet the principle of completeness. References are made as well to this idea of consistency. The tribunal says the rules of the federal law on administrative procedures cannot be applied as the claimant wants. What we need to do is to look at the notice clause in the contract. We have to see what the contract says. And the contract says that notices must be made using a courier with an acknowledgement or receipt, or a personal notice must be sent to the parties' representatives. And when we're talking about legal notifications, those need to be made to the legal representative directly. In spite of this analysis, in very few words, the tribunal says that when this work order 28/2016 was notified via a log, that is more than sufficient. The contractor should have said that it got the notice and it should have carried out the work order. If we look at clause 24 that talks about logs, we see that those logs are not a means of communication under the contract. These logs are used simply to record events or circumstances or matters that take place during the implementation of the works. And the tribunal cites case law supporting this conclusion. The logs, in accordance with this definition and with the multiple examples we have in the clauses of the contract, well, the logs are not a means of communication. They are there to support important facts and events, if necessary, related to the parties to the contract. Now, in connection with rationale and justification, there are many examples of this. Perhaps the tribunal may reach some conclusions, but we see that the conclusions reached by the tribunal lack legal justification. Sometimes they cite the applicable legal provisions, but the justifications by the tribunal to justify the application of a certain provision, those are not sufficient. We have the issue of PACMA, which is very important in the sense that the tribunal ruled against the companies because it says the companies have not shown the main argument of why you didn't comply with PACMA. You provided no evidence that shows that there is a relationship between the minimum amount of the contract and the performance of the PACMA. Now, the private parties tried to evidence this, which was an expert opinion in connection with cost engineering. According to the private parties, there was no other element that would allow for it, from a technical viewpoint, to show the existence of this technical engineering accounting link that could be shown to convince the tribunal. The tribunal simply said, this expert opinion is based on a legal interpretation. This is the interpretation of the provisions of the contract. I am an expert in the law, said the tribunal, and I do not have to take into account this expert opinion to decide on this matter in particular. All of this is incorrectly grounded and reasoned. In spite of the fact that they analyzed all of the provisions of the contract, how notices are given to the parties, the tribunal, however, simply said that if something is recorded in the logbooks, and in spite of what the provision says in connection with the logbooks and the thesis that it entails, well, we don't know why the tribunal says that the contractor must have deemed to have been given notice via the logbooks, and why, because of that, it had to perform and fulfill the work order. More irregularities. The chamber of the tribunal, the superior chamber, in the judgment, fabricated an obligation that indicates that the parties should monitor all of the records in the logbook, in spite of the fact that the works were suspended. Without any support or major support, the tribunal said, okay, the claimant says that no works existed, but the claimant should have been kept abreast of whatever was recorded in the logbook at all times. there was no formal suspension, it was said yesterday, according to the contract, but it was recognized, but for a number of months, no work orders were issued. So there was no work because there were no work orders. No work was being performed. According to the descriptions, the logbooks, and the thesis put forth by the tribunal, there was no event to record in the logbooks so that the contractor could have knowledge of these events in the logbooks. However, the tribunal, without any support whatsoever, said, okay, it's not enough to say that since there were no works, you didn't really have to have information of the existence of the work order. Because of time, I'm not going to talk about what the multi-judge court, the collegiate court, said in connection with some of the breaches.
I don't think I can understand what you said. When? Let me reread the transcript. Therefore, based on the description in the logbooks and also the thesis by the tribunal, there was no incident or event to record in those logs so that the contracting party would be informed of any records in that log. Let me try to find where. Your phrase is, given that there were no work orders, etc., given that there were no work orders, there were no works, therefore, and based on the description in the logs and also the thesis by the tribunal itself, there was no incident, event, or fact to record in those logs for the contractor to be aware of any record in those logbooks. What I would like to highlight, arbitrator, is that the tribunal goes against its own motivation. What they said, on the one hand, is that the logs will be used to record facts, and for them it was enough to record the existence of a work order. Those are their grounds. And then they also recognized that even though there was no formal suspension of the contract, there was, for several months, an absence of work orders. And I think that the proper portion of the decision was read yesterday, but it was recognized that for several months, even though Pemex did not recognize a suspension of the works, they did recognize that because of an inadequate budget, they are not issuing work orders. And I understand that this continued for almost a year. So the tribunal concludes that in spite of all of the reasoning and motivations used, the logs are used to record facts that took place during the occurrence of works. If there is no work order, there is no works. There are no works. I have no incident. I have no event to be watching out for. And in spite of all of those motivations, the tribunal concluded that since there was no formal suspension of the contract, even though there were no works, no work order underway, the tribunal said that at all times I had to be aware of the record in any log to notify, for example, a work order. That's the inconsistency that we wanted to point out to. Mr. President, with the support of the Secretary of the Tribunal, I would like to know how long the experts have been having their presentation. Yes, but
My colleague.
I did deduct it. It was paused. They've been talking for 29 minutes. I was about to.
Gracias. Estoy a punto de concluir, señores árbitros.
I'm about to conclude, arbitrators. Now, in connection with the multi-judge tribunal, we also have an issue. The multi-judge tribunal confirmed the Federal Administrative tribunal's decision because novel arguments were introduced. But the multi-judge court once again indicates that the argument indicating that the claimant showed, for example, that for the notification by means of a notary, the communication to the notary to carry out that act was after the date when that notary notification took place. That inconsistency was enforced since the annulment decision. It was refuted by the court saying that it was just a typo, but it was registered as a grievance in the direct amparo. The multi-judge court said you didn't do it from the outset, you didn't implement it, it is a new argument and it will be dismissed. There is something else that is important, and it has to do with the ex parte communications, and I am about to finish. The ex parte communications have to do with that discussion that the judge has with the party, which we see in the in any civil or administrative proceeding. Administratively, it has some elements so that the practice is not an undue practice. First, the party requesting a hearing with the judge needs to be a legal representative or a lawyer that has been authorized by one of the parties. So there is no dealing directly with the judge, and this is something that is really looked into by the tribunal, so the other party has to be present whenever a conversation takes place with the judge, and it is completely irregular for a judge to anticipate a decision to a party. Mainly when we're talking about a multi-judge court, it would be like anticipating the votes of the other members of the multi-judge court. I have a question. The judge needs to turn on the mic, please. You're saying that this is recognized, but on the other hand, you're telling me that it is not allowed to deal directly with the administrative court. Is it banned or not? Let me explain. As I was just saying, one of the requirements to be able to talk to the members of the court is for the party to prove that that party is a legal representative or I am an authorized lawyer by one of the parties. I should not only state it in the claim, but it should also be recognized in an agreement with the court. What does it mean? I am no longer just someone managing a case, but I am someone who has been recognized by the parties as being an authorized representative. And this is also reviewed by those that review the case with the judge. That is something that is confirmed by those who work with the judge. Under the administrative law, there is no possibility to appear before the judge for this type of discussion without being an authorized representative. So the idea is to prevent that anyone that may say that has an influence on one of the judges may go to advocate, trying to exert pressure without that official capacity as a representative, party representative. All of this violates the ethics code of the administrative court. And now as to contract 804, Mr. President, I think that they are beyond time. Yes, they are beyond the time, but would respondent accept to give experts an extra 4 or 5 minutes so that we can also offer those 4 minutes to experts of respondent. We'd like to cooperate, be flexible. The idea is to have time for everyone to ask questions. I would ask you, Mr. Amezquita, to be reasonable with the time you are going to use beyond the time you had for your presentation. 3 or 4 minutes, 5 seconds. Now, in connection with 804, we would only be interested to indicate that the irregularity we saw was the time incurred between the civil and administrative proceedings. That was more than 5 years, and the parties did not have a resolution. That is to say, no, there was no resolution of the case. Thank you very much. And now I give the floor to Mr. Bonfiglio for cross-examination. I thank you, Mr. President. Good morning, Mr. Amezquita, Mr. Zamora. My name is Alan Bonfiglio, and on behalf of the United Mexican States, I will be asking you some questions with my support of my colleague Laura Mejia. We will be displaying some documents on the screen. I understand that the leading expert could be Mr. Zamora, but when I ask a question regarding the civil aspect, civil litigation will be for you, Mr. Zamora, and as to administrative issues will be dealt with you, Mr. Amezquita. Do you agree?
The division of the topics, I wouldn't just say that there is a leader in the expert opinion. This is a twofold expert opinion. It has an opinion on civil litigation, that's my area, and it has a section on administrative litigation, and that's Mr. Amezquita's area.
Trataré de...
I will endeavor to establish that difference, but it's really striking that you speak in English, and you indicated that you were going to make your statement in Spanish, and then in November we also received a notice that you were going to speak in Spanish, and we just want to be practical and ask you to speak in Spanish.
Sorry.
Justamente por esta situación.
I apologize. The reason I am testifying in English is in the benefit of the 3 members of the arbitral tribunal. But I am available if the tribunal so instructs to testify in English or Spanish, whatever is best for the conduction of the hearing.
I apologize. I do not speak Spanish, but the translation is very good. So it's really up to you.
De esta forma, quiescence of my colleague, Mr. Pelé, I think it would be more efficient for you to declare in Spanish, even if I'm now speaking in English. Pero, o sea, aunque pueda ser un poco paradójico, yo creo.
I think it would be more efficient and faster for you to answer in Spanish. Y las demandantes pueden seguir también la respuesta.
Yes, my apologies. I'm mixing languages. No, I say, do you object to Mr. Zamora declaring in Spanish?
No, whatever's best for the tribunal.
Okay. So, again, with the acquiescence of Mr. Pelé, I think you rather respond in Spanish, please.
Y lo digo con apertura. Creo que...
And let me be open. I think that both parties would like to have a clear transcript, and it will be for everyone's benefit. Thank you, Mr. Zamora. I will ask you some questions regarding the contracts. I imagine that these questions need to be addressed to you, Mr. Amezquita. Why don't you ask the question and we decide who will answer? So only one can answer based on procedural resolution number 9. Procedural order number 9? Yes, by the tribunal. Only one expert may address my question. Contract 803. It was signed in February 2012 after BCEL and MWS were awarded a public bid that was organized by PEP, correct? As to dates, we need to review the contract, but I should take your word as to the date the contract was signed and the parties that signed it. But you'd agree that it was on that date. If that's what the document states, we would need to look at the document. But if there is a date and it was signed a couple of days before or after, but the document states whatever it states, would you believe me if I told you that on March 20th, 2013, after BCEL and MWS were selected, they entered into this contract with PEP, correct? We can look at the experts' report. There we see the date, but whatever date is registered in the document, that would be the date. Would you agree with me that 803, 804, and 821 were awarded by means of a public bidding process, by means of a public procurement process? Well, the documents state the type of procedure. We saw the contracts. Our expert's opinion has to do with the procedures after the contract, and the contracts may state the procedure followed for their signature. So you're telling me that you don't recall? No, I'm just saying that we need to look at the documents and whether it was through a bidding process or not. Agreed. In 2013, there was something that is known as the energy reform. Are you familiar with it? Somehow, even though this is beyond the scope of our analysis of the litigation, but you're familiar with it. I have vaguely heard something about that energy reform, but I am not in a position to answer any questions about the energy reform. Understood. In 2013, there was an energy reform, and after that, a secondary legislation or a secondary law came into effect. Do you recall? Well, I recall that through that reform, there were some modifications, and once again, that goes beyond my expert's opinion, but I understand that the reform amendment amended some regulations. My question is relevant because starting with that reform, a PEMEX law was passed in 2014 that abrogated a law, a PEMEX law of 2008. Yes, that is correct. 2014 law amended the 2008 or abrogated it. Now, the effect of that amendment or abrogation is not what I discussed in my report. Do you know that 804, 821, and 803 were governed by the 2008 PEMEX law?
He said like 4 times that this goes beyond his expert report. He did not opine on the PEMEX law, 2008, 2014, its effect on the contracts. They're here to talk about the judicial proceedings that took place in Mexico. And I don't know where we're going with this, but...
Señor Presidente, ¿la ley aplicable a los contratos?
Mr. President, the law applicable to the contracts is quite basic. It's the PEMEX law of 2008. Agreed, but if you could please ask questions that do not have such an obvious answer, that would be useful for the tribunal. But you own your time. Understood. Now, with the PEMEX law of 2014, more certainty was given to PEMEX procurement process. That is to say, it establishes that the procurement process is of administrative nature, but once the contract is signed, it becomes of a commercial nature. Were you aware of this? As I mentioned before, the purpose of the expert's opinion, of both experts' opinions, is to analyze the judicial proceedings for 803, 804, and 821. And as to the references that you are making in connection with these reforms, we have heard of them, but the scope of those reforms, the 2014 reform, is not the purpose of my opinion. Another question that is relevant to your experience and also bearing in mind the contracts is as follows. If these contracts that were entered into under the 2008 PEMEX law, and if there was no arbitration clause, the administrative path was the right path to follow for any solution, correct? Could you repeat? Yes. The 2008 contracts that were entered into by Pemex, in case there was no arbitration clause, any dispute had to be resolved by the administrative court, correct? Whatever the court is chosen, but whatever was indicated is that during the 2008 law, there were some criteria determining how to resolve the issues and how to resolve the disputes. But then we saw that through 3 proceedings, 803, 4, and 21, we see that there were some decisions, and none of them is identical throughout 3 proceedings, different decisions, different contracts, and that clearly had an impact on the treatment that the parties received. Thank you for your clarification. Now we're going to look at some provisions under the contracts. I would like to show you, for the record, this is C34, this is contract 821. And for the benefit of both, we will be showing some documents on the screen, but you can also see them on the screen. If we look at page 12, a little bit below, we see that the parties consented to entering into a contract, in particular 821. At least on this screen, we do not see page 12, we see page 8. And also, would you please make the reference to the section of the expert report where we address that topic. So you did not analyze contract 821. So I'm asking you where I mentioned that section in my report, but you know that as an expert on Mexican law, I may ask you questions of a legal nature in connection with the contracts that were in dispute. Well, my understanding is that our appearance is to answer questions about topics that we addressed in our report. We are Mexican lawyers, but it doesn't mean that you can ask us any question on any document for the analysis and the conclusions that we reach in our expert report. I apologize, Mr. Zamora. If you do not want to answer a question, you can say no, but I think that Council has the right to ask you questions that, even though they are not mentioned under a specific paragraph, are directly related and they may be useful. So if there is something that goes beyond your area of expertise, please let us know. But I think it is legitimate for the Council to ask you questions related to your area of expertise. Okay, could you please repeat the question and show on the screen the section? Certainly. We're going to see some clauses, but you're saying that you are willing to analyze the questions that you have asked.
Was he was not tendered to be a contract expert. We leave that up to the tribunal, and they want to. And also, they did not offer opinion on the specific provisions of the contract. What they offered an opinion on was how the contract worked with the decisions that were made in the Mexican courts. And this activity here is not what they opined upon. Mr. Asali did get into contract interpretation, but our experts did not.
Yes, that's right, but my point is that if Mr. Zamora thinks that the question goes beyond the scope of his report, he should say so. But let's not constrain a priori the possibility for Mr. Bonfiglio to raise questions which are closely directed. Later on, the tribunal itself might pose questions which are not related to a specific paragraph of your report. So let's be relatively open with respect to the questions, and you be as strict as you consider fit in your responses.
Gracias, señor presidente.
Thank you, Mr. President. Let us look at page 46 of C34, clause 15. In this clause, the parties agreed that contract 821 could be rescinded by PEP or by claimants, correct? Or Drake in this case, correct. In the last sentence, we can scroll down. It says that PEP may administratively terminate the contract whenever the contractor is located in any of the following cases. Do you see that? Yes. In other words, PEP could terminate contract 821 given non-compliance with any of the 19 grounds listed here. Correct. Now let us look at R42. This is the decision of August 28, 2017. Were you familiar with this document? Yes. I would like to show you page 17. There we read that Pemex took into account for the rescission the non-compliance of subparagraph B, 15B, correct? Among others? Yes. Agreed. Understood. The second grounds for rescission that we can see at page 20 was that Pemex rescinded the contract under C, 15C, correct? S, rather. S, not C, S. Yes, if we look at page 31 of this document, we see that Pemex took into account several grounds to rescind or terminate contract 821. You can see clause 2, 19, article 48, annex PACMA that you also mentioned in your presentation, DT2. My question to you is, there are several breaches and grounds that are hereby mentioned in this resolution, correct? If you allow me, once again, I go back to the report. Please answer yes or no, and if you want, you can elaborate. No. Let me start with my report. My report has to do with the decision by the court because of the grounds for termination that indeed were basically based on subparagraphs B and S. The court, and that's why I was referring back to what the court said and also what we stated in the report. The court said that even though it is true that several alleged grounds of noncompliance by Pemex were enforced, the court basically analyzed two things. Subparagraph B, since it has to do with the alleged breach, that the companies did not comply with the order to receive and sign the work order, and number two, in connection with subparagraph S, the court said that since the work order was not implemented, and number two, because there was breach of PACMA. This was the summary by the administrative court to determine the case. So I am not saying that it was not Pemex's intent to show various grounds of breach, but what I am saying is how the tribunal addressed this to simplify the analysis of the case. I thank you for your answer. Now my question for you is, was it enough to have one breach of Clause 15 for Contract 821 to be terminated? Correct.
In this Clause 15, one can also see that Contract 821, and if you'd like, we can go to that part in just a second so that you can see it on the screen as well. In the event that the claimants in this case, Drake Bissell, were to breach some clause, then PEP could grant a period for curing said non-fulfillment, correct? Yes, that is correct. I understand that there was a clause that provided for the possibility of giving an option to cure the breach. So it wasn't an obligation of PEP, but it did have the option of drawing on this possibility to cure the breach. No, I don't agree. This rescission procedure, according to the theses, is administrative in nature. Pemex here is not acting like just any grantor of a contract on an equal plane. Rather, it is acting as an authority, so much so that the resolution on the rescission procedure was challenged through the Federal Court of Administrative Justice. If it were on an equal playing field, then that authority would not, or that court would not have jurisdiction. What am I referring to? Well, with respect to the question of whether Pemex is or is not able to afford that opportunity to cure any irregularity or any non-fulfillment. Well, if we follow this line of interpretation, which has already been endorsed by the court on other occasions, we're talking about an administrative procedure. Any rescission proceeding is administrative in nature. Point 2, therefore, it is a regulated procedure. Regulated means it is subject to very strict principles. And it's not necessarily because the clause says it may, should that be understood literally. We may be in the presence of a shall. Now, in the specific case, what does it depend on? Well, depending on the ground for the alleged breach or non-fulfillment, I have to review, as Pemex, whether there are possibilities of granting an extra time period or some option to be able to cure that breach. That possibility existed. It's stipulated in the contract. Agreed. Are you aware that PEP sought on 4 occasions, it sought out Drake for it to cure the breaches under Contract 821 on 4 occasions? The judgment says nothing in this regard. I'd like to show you quickly R109. Let's blow it up a bit so that you can see it well. Up at the top, you can see that it is from 16 December 2016. Under matter or subject, it says notice of breach of Contract 821, and a bit further on, if we could. Here you can see a paragraph that says, in view of the foregoing, we ask that you immediately go to, and then you can see what it says, with the aim of regularizing. Were you aware of this official communication? I repeat that it was not cited anywhere in what I saw in the record. Okay. I'd like us to go back, please, to C34. Let's go to Clause 15. And that's on page 15. Minimum and maximum amount. Now, in the second paragraph here, it says that PEP shall not be obligated to use up to the maximum amount of the contract. Can you see that? Yes. Now, I'd like us to turn to clause 44, which is on page 84. And you can see in the second paragraph of this clause 44 that the work orders could not go beyond the maximum amount of the contract. Do you agree that it says that? Yes. And would you agree with me that this contract 821 established that it was not an obligation to use up to the maximum amount and much less to go beyond it? Correct? Apparently so. You just saw it on the screen. Yes, that's why I say apparently yes. And I say apparently because none of this was argued, at least from what one sees in the judgment, none of this was argued, and so it wasn't covered in my analysis. Fine, I take note of that. Now let us go to page 50 of Contract 821 to show you clause 15.3. This clause authorizes the contractor, in this case Drake, to rescind the contract for some non-compliance on the part of PEP. Taking into account this provision, the claimants in this case, Drake, they had a means of defending themselves in the face of a non-fulfillment of the contract by PEP. Is that right? According to what the clause says, yes, apparently so. Okay, thank you. And among the aspects of noncompliance that Drake Finley could claim against PEP was not having permits, licenses, or authorizations that were up to it, right? They were up to Pemex. Yes, exactly. Thank you. Do you know whether Drake brought a claim against PEP seeking rescission of Contract 821 under this Clause 15.3 of Contract 821? No, it does not appear from a reading of the court's record that there was any kind of legal action brought by the contractors against Pemex. But note, you are mixing up something which has to do with you bringing an action, which is very normal in contracts, where I need to request rescission of a contract before a court against a clause in the civil law, such as Pemex has, to rescind the contract on its own initiative and immediately. That possibility existed, as we just saw. Yes, but it could also be the case that it sought to, now I'm assuming, because none of this is in the record, that the contractor didn't want to use this option in benefit of the good faith contract clause in the contract. I take note of that. I want to talk with you now about termination of contracts. Let us begin chronologically. Okay? Sure. Now, if we first look at C32, you'll see Contract 803 up on the screen. And if we go down to Clause 3, the duration of this contract was from February 2013 to December of 2013, correct? Yes? Thank you. Months later, and I'll now show you R59, the parties agreed and signed a modifying agreement which established 30 June 2014 as the new end date. Were you aware of that? Nothing of that is said in the record of the trial. Were you familiar with the new termination date of Contract 803? If it wasn't in the record that I had before me for my review, then no. I'd like us to please go back to C32. let's go to Clause 2, which we just saw. There it is established that the term of this contract begins at the moment it is signed. Isn't that so? Mm-hmm. For the record, you need to say yes or no, Mr. Amezquita. You're referring to Clause 2 on term, correct? Yes, that's right. Yes, there it says that the term of this contract begins as of its signing. Agreed. And based on the same clause, Contract 803 ends when the legal act that terminates the rights and obligations of the party is formalized. I'm sorry, I did not analyze Contract 803. You're telling me that you don't know what this clause says, or that it was not part of what you... I see what we're reading. I'm not familiar with Contract 803. You're not familiar with Contract 803? You're telling this international tribunal that you did not analyze 803? I only analyzed 821 and 804 on administrative litigation. 803 was not the subject of my analysis. In your presentation, when you introduced yourself to this tribunal, you said that you have quite a bit of experience in procedures having to do with this type of contract, and you used the word finiquito, right? Yes. You're familiar with what finiquito is, right? Yes, but that doesn't mean that the procedure the proceeding in Contract 803 was subject of my review. I'm going to ask you a very specific question. Go ahead. Contract 803 ended with the signing of its finiquito. Is that correct? What does the contract say with respect to the duration? It's what you just saw on the screen. It's Clause 2. Just a moment. The experts have told us that Mr. Amezquita is specialized in the administrative jurisdiction, which only affected Contracts 804 and 821, and that Mr. Zamora is familiar with the civil jurisdiction. I don't know if this question should be directed to Mr. Zamora insofar as in his analysis of those records in the civil jurisdiction, including Contract 803, whether he was able to analyze this contract. In other words, I think this should not go to the expert who did not analyze this contract, and perhaps it's Mr. Zamora who could answer. I don't want to interfere, but based on the division of labor that the experts themselves have described, I think that questions on civil law jurisdiction should go to Mr. Zamora, and on administrative law should go to Mr. Amezquita. Well, this is actually my question is actually administrative in nature. My question for you, Mr. Amezquita, and I'm going to ask you once again. When the finiquito to Contract 803 was signed, Contract 803 no longer had any effect. Is that correct? No microphone. No microphone. According to this clause, read in isolation of this document that you're showing me, the term of this contract begins as of the date of its signing. Now, in your experience in administrative law, do the obligations and rights extinguish when the finiquito of an administrative contract is signed? It depends on what's been put in the contract, what was agreed upon in the contract. Well, let me take you once again to Clause 2, which speaks of the term of the contract. Can you see that it states in crystal clear terms that the contract begins as of the date of its signing, and it concludes once the legal act by which all of the rights and obligations of the parties are extinguished is formalized?
Mr. Bonfilio is playing games. And it's because he knows that the finiquito actually says it doesn't extinguish it. And he doesn't want to show him, and he's asked to see it. So can he see the finiquitos if he's going to ask him about finiquitos?
Pero por supuesto, por favor, vayamos.
Of course. Let us go to an exhibit R15. Had you read the finiquito for Contract 803 before, Mr. Amezquita? No, but you're familiar with finiquito, right? Yes. It is a concept from the administrative law, correct? It's not exclusive to administrative law, but yes. here it is entered into on 10 February 2015. My question for you is, if this is the date of the finiquito for Contract 803, the consequence is that the rights and obligations of the parties under Contract 803 are extinguished, correct? According to the clause you showed me earlier, it depends. If through this legal instrument, all the rights and obligations are extinguished. If that is not what the finiquito says, then the term of the contract has not ended. Do you acknowledge that Contract 803 was terminated? It's no longer in force, correct? I would think so, but I didn't get into the history of Contract 803. Do you know if there was some proceeding initiated by MWS and Bissell in which they have fought the finiquito that is up on the screen? The only thing I know is that there was no administrative procedure before courts with respect to Contract 803, and therefore it was not subject of my analysis. Do you know whether Contract 803 is in force? I don't know whether it's in force. It was simply not the subject of my analysis because, as far as I know, it never reached an administrative trial, so I never reviewed it. The finiquito is an administrative act, correct? In this instance, yes, it could be an act that is mixed in nature. Why? Well, with respect to the authority that issues it, it's normally an imposition, a unilateral imposition by Pemex. The terms of the finiquito is practically an adhesion contract where the other party has to adhere to those terms. We would have to look at the text of the finiquito to know, in relation to the clause that you showed me earlier, whether with this finiquito actually does totally extinguish the rights and obligations. That is something that was committed to in the previous clause. That wasn't my question. I'm going to put it to you once again. My question for you is, the finiquito, in relation to Contract 803, administrative in nature, the finiquito is an administrative act, correct? It could be considered an administrative act when it is issued by Pemex, and it's even used to go to courts, yes. And would you agree with me that under administrative law, administrative acts are valid until a decision is issued that says the contrary? Is that right? They enjoy a presumption of validity, and that is something I referred to. Yes. Thank you very much. That's very useful. I would now like to ask a couple of very similar questions related to Contract 804. If we could please go to C33. Particularly Clause 4. This contract established an initial duration of that would run from 20 March 2013 to September 30th, 2013. Can you see that up on the screen? Yes. Just as happened with Contract 803, there was a modifying agreement that changed the term of Contract 804. That is to say, it now has a duration, or it had a duration up to 31 March 2014. I know that this is, I'm really pressing your memory in terms of the dates, but did you know that this term had been modified? No, because neither of the parties ever said so in the proceedings that I reviewed. Agreed. I'd now like to show you Annex or Exhibit R16, which is the finiquito for Contract 804. This document was signed on 10 April 2015. My question for you is, this legal act also extinguished rights and obligations in respect of Contract 804, correct? I don't know. What did they agree in the finiquito? You did not. I did not analyze the finiquito for Contract 803. You did not analyze the finiquito for 803 or 804 for this hearing? I did not analyze anything other than the administrative proceedings that I reviewed. Very well. Now, having pointed out finiquito for 804, it was not combated and it was not the subject matter of litigation brought by MWS and Bissell, correct? That's right. It was not a subject in the proceedings that I reviewed. And like what was indicated earlier, administrative acts are presumed valid until there's a resolution that states the contrary. That is right. Thank you. I would like to ask you a couple of very similar questions, but now with respect to Contract 821. I'd like to show you Exhibit C34, and if we turn to page 46, you'll see Clause 15.1. Here it is mentioned that PEP may at any time receive administratively rescind the contract without a need for any judicial or arbitral declaration. Do you see that up on the screen? What does it mean that PEP does not have to declare the rescission before a judicial or arbitral body? That is what is called a special clause of private law, which means that the authority has special powers in contracts of this sort so as to, on its own, for any ground of rescission of the contract that's provided for, may terminate it immediately without having to turn to the courts. And that is because contracts of this sort have as their purpose to satisfy, in principle, a collective need. They're a matter of public policy and social interest, and in light of the importance of their purpose, the authorities that enter into them with private parties are given special powers, as in this the case of administrative rescission. I don't know if that's what you're referring to. Yes, thank you very much. In essence, what you're telling me is that it means that PEP did not have to validate the rescission of Contract 821 either in the courts or by going to arbitration. No, it only has to substantiate the administrative rescission proceeding. Now, the resolution on rescission of Contract 821 was issued by PEP in August of 2017, and notice of it was given in August of 2017 to Drake. Do you recall that? Yes, it said so as between the parties. I'd like to show you now R42. It's the resolution that I just mentioned of 28 August 2017. This ruling declared Contract 821 rescinded. Were you familiar with this document? This is the administrative rescission resolution? Yes. That was challenged before the Federal Administrative Law Justice Court? Yes. Because it was transcribed in the judgment, I am familiar with it. Okay. This is the act that rescinds Contract 821, correct? Well, yes, it's what is transcribed in the judgment. And going back to what was said with respect to 803 and 804, an administrative act is valid until such time as it is declared otherwise through a resolution. That's the general rule under the Federal Law and Administrative Procedure. Do you know whether some court declared that this resolution was invalid? No, it was not declared to be, or it was not found to be invalid. Thank you. I'm now going to ask you a series of questions regarding litigation. The ones that are civil litigation will be for Mr. Zamora, and the ones on administrative litigation I will direct them those questions to you. Now, this one can be for the two. You can decide who will answer it. But I'd like you to help me understand the structure of the federal judiciary of Mexico. In very general terms, the federal judiciary is made up of district judges, single judge courts, multi-judge courts, and the Supreme Court of Justice, correct? Just subject to a change in name, what you called single judge courts, well, in some of the opinions, these are called collegial appellate courts or courts of appeal, but apart from that, that is the main organizational chart of the federal judiciary. Thank you. Now, the judges who have jurisdiction at the first instance to hear federal, civil, and commercial trials are the district judges, correct? Yes, that's right. And the courts that have jurisdiction to act as a court of appeal in federal trials are the single judge or multi-judge courts or courts of appeal. Yes, they used to be called single judge courts or tribunales unitarios. We can continue calling them that if you'd like. Well, since in the entire record that is what they're called, we'll use that term. Okay, but you agree with me that that is the second instance or appellate instance? Yes. Moreover, these district courts, the single judge courts and the multi-judge courts also have jurisdiction to hear what in Mexican law is known as an amparo proceeding, correct? Yes, that is correct. And the federal judiciary is divided into circuits. Is that so? Yes, for the benefit of the arbitral tribunal. Yes, the circuits are geographic regions of the country. The United States of Mexico has 18 or 20 circuits. Approximately, they don't correspond each circuit to a state. There are different arrangements, but there are different circuits, geographically speaking. The first circuit is Mexico City, correct? Yes, that is correct. And the state of Veracruz, which circuit is it? The seventh, if my memory serves me well. These two circuits are the relevant ones for the trials that were the subject matter of your reports, correct? Yes, and just to clarify, the Seventh Circuit might or might not cover all of Veracruz, or it might also include some parts of other states, but that's irrelevant for our purposes here. Thank you. And Mr. Amezquita, there is a federal Court of Administrative Justice. What is the judicial instance for or body that would hear administrative nullity actions or administrative litigation? It would be this, right? Yes. And the final judgments of the Federal Court of Administrative Justice may be litigated, or I should say challenged, through an amparo proceeding, correct? Yes, a direct amparo. Now, a question which perhaps for both of you, but let's begin with you. Those 25 years, or I'm sorry, 30 years of experience, you said. 30 years of experience, obviously that includes, as is generally the case in Mexico, some years during the university when I was also working. I worked in litigation, commercial litigation, as of 1991, even though I got my degree in 1996 and my diploma in 97. So, in your 30 years of experience, have you ever litigated against productive enterprises of the state, such as Pemex? Yes, I have. And in those cases, respecting professional confidentiality, your clients in this litigation against productive enterprises of the state, have they prevailed? Have they turned out to be the winners in these trials? There are two issues in my experience, and as you say, preserving the confidentiality. There have been different sorts of results, and some they've not prevailed, and others they have prevailed, recognizing that I would say most of those matters have been before arbitral tribunals. Fine. So it is possible to get a favorable resolution in litigation against productive enterprises of the state if one mounts an adequate defense and legal strategy, correct? Well, I think one must. It's a very simple question. If you want, after answering, if you want to add whatever you'd like. But it is possible, right? Everything in life, or practically everything in life, is possible. What I would say is it depends on many factors. It depends on factors which might have to do with the amount in controversy, the issues that might exist in the commercial relationship with the party that is adverse to Pemex, and it depends on the jurisdiction of the court, whether it's a judge or an arbitral tribunal, the solidity of the arguments. It depends on any number of factors. This is a very powerful opponent, so to speak, to put it in terms that anyone could understand. CFE or Pemex in any party is an important party, but in some cases one has prevailed and others not. It depends on any number of factors. So it is possible. Well, many things are possible, and it really depends on a case-by-case basis. I would not come up with a general rule with respect to Pemex or any other entities or enterprises. Very well, I take note of that. Likewise with you, Mr. Amesquita, you've litigated on behalf of and in representation of your clients against productive enterprises of the state, correct? Yes, and your clients have prevailed in such litigation, considering sometimes they have and sometimes they've not. On some occasions, yes, we've been able to get favorable results for the private parties against productive enterprise of the state. Would you agree with me and Mr. Zamora that it is possible to beat a productive enterprise of the state? Yes, it is possible. I would just clarify that there are also cases which, as we call them in practice, become politicized. That is to say, depending on their importance for the public fisc or the productive enterprise of the state itself, they might a matter might come to have such magnitude or importance that there would be special lobbying by the authorities before the courts. Yes.
I take due note of that. Mr. President, I see that 90 minutes have elapsed, and I put to you whether you think that this is the right time to take a break. Agreed. Let us take a 15-minute break. We'll reconvene at 10:15. 10:15 then. Thank you, Mr. President.
A lo mejor es una obviedad, señor.
Perhaps this is obvious, Mr. President, but the experts are sequestered. Is that right, sir? Yes, of course. You can go, have a pastry, get some coffee, but you cannot talk to anyone.
¿Listos ya para continuar?
Are we ready to resume? We are ready, Mr. President. I think we're all here. Please go ahead, Mr. Bonfilio. Thank you very much, Mr. President. I'm going to ask you a series of questions in connection with administrative and judicial proceedings. The COVID-19 pandemic had an impact on the judiciary of Mexico as to the workload. Well, I would say yes, in the administration of civil justice, yes, it had an impact. COVID had an impact on everything. We would have to look at everything. Of course, all these claims of 803, 804, and 821 were pending before the judiciary of Mexico. The courts were closed in Mexico for a few months. Then it was working with a limited capacity. I don't have the exact date here, but I think the period of time was about 4 or 5 months. Then September, October, I think things recovered, and then it continued to work at the same pace as before. So there were no activities during a period of time, is that right? Well, I don't think that has an impact on my conclusions in my report. Mr. Mesquita, was the administrative court also impacted because of the COVID-19 pandemic? Yes. Contract 821 led to a civil proceeding and to administrative proceeding, and there's a distinction, of course, that has to be drawn for the purposes of all of us here, and please help me in this regard. I'm going to ask you a few questions related to the civil proceeding. This is Civil Proceeding 200-2016. That's what we've called it. And in your report, Mr. Zamora, you called it CP 821. Is that right? Yes, that's right. This civil proceeding commenced in April 2016 before the 8th District Court. Drake Finley asked for a number of amounts of PEP because of breaches of 821, correct? Again, the date was on the screen. It was 2016, but it wasn't only Drake Finley. There were other companies involved, yes, but it was before the 8th District Court of the State of Mexico. But you recall it was in 2016, right? Yes, that's correct. In your experience representing claimants and respondents in federal civil proceedings, when your claim is based on non-payment because of contractual breaches, you also look at the damage created by the breach of contract. Is that right? I'm not sure I'm understanding your question correctly. I'm going to try to answer it. If I don't answer it, please let me know. When you bring a case in connection with a breach, and in connection with that claim, you present a case, well, the way in which you present the case is going to have to do with the way in which you draft the case. So when you're claiming damages, you have to know the amount claimed that is included in the initial writ of claim, correct? Well, we have different rules in the Mexican civil procedure. You're asking whether the amount must be known and whether that amount needs to be explained when the complaint deals with damages. You have a number of claims you can bring during a proceeding. Let me give you an example of a promissory note. In a promissory note, you have the principal amount, you have interest, and you have perhaps other claims. There are other claims where I say, okay, the contract was breached and this created a damage for me. This depends on the way in which the claim is put. You have to understand what an obligation is under the contract, and if you can consider the breach as a damage, or if there are other monetary claims that have to do with specific things, you have to show the tribunal under specific rules. Of course, there are different courts that decide this differently. In proceeding 200-2016, Drake Finley, in the complaint, established an amount of claim against PEP, right? The claims in that complaint establish specific amounts. The fact that those amounts were established there and what the consequences are of that, well, you have to look at that. But yes, the claims had amounts attached to them. The claim was submitted in April 2016, and then, of course, the evidentiary period starts in this civil proceeding. Is that right? Well, it's not something immediate. What you do is you bring a claim, just like you did in 803 and 804. In those cases, they had been dismissed because of administrative issues. And, of course, in this case, the court receives the complaint. It orders for notice to be given to the other party. In Mexico, the notice is not done by the council themselves, but by the court. Notice is given to PEP. Then PEP answers the complaint. Then it brings the objections that it wants to bring, and then the evidentiary period starts. Yes, before going to the evidentiary period of 200-2016, there were other stages that happened before. What is the evidentiary period? Well, the evidentiary period is a period where the parties submit testimony, witness statements, and expert witness statements, and then the judge decides the evidence that he or she admits or rejects, and then the court receives the evidence. For example, if we have witness testimony, you set up a hearing for the witnesses to be heard. If they're expert witnesses, then you set up a hearing for the expert witnesses to be heard. In the case of 200-2016, this proceeding, the claimants in that case, Drake, Finley et al., offered expert opinions in connection with engineering matters, correct? Yes, correct. This meant that Pemex had to provide its own expert witness evidence to answer to that, or to rebut that engineering expert opinion. Do you recall it? Well, sir, excuse me, you said Pemex was obligated to do it. No. When an expert opinion is submitted, an engineering expert's opinion is submitted, then the other party is given the opportunity to also submit expert witness to rebut the expert witness submitted by the opposing party. But of course, yes, the opportunity was given to Pemex, and Pemex submitted expert witness opinion. So this happened during the evidentiary period. So PEP submitted an expert opinion on engineering. Is that correct? That's correct. Let us look at R45. And let's look at page 14. This is a judgment in this civil proceeding. And you can see here that Drake Finley, in November 2016, submitted an expansion of the complaint. Is that correct? What is an expansion of the complaint? Can you help us with this? Well, this is a legal institute, which is included in the procedural codes, that allows the claimant, and in this case this was November 2016, to submit additional elements to the court for the court to consider them. And this is what happened here. For the benefit of the tribunal, what we see here is the final judgment of the district court of the first instance in connection with 200/2016. So an expansion of the complaint was allowed, notice was given to the other party, and the answer was to be provided by the respondent. So when an expansion of a complaint is allowed, then the other party must answer to that. Is that correct? Yes. This is what number 6 here states. Let us move ahead in time, and in November 2017, the district judge rendered a judgment deciding proceeding 200/2016. The judge said that it lacked competition because A21 had an arbitration clause in it, correct? Yes, correct. That's exactly the document we're looking at. So in this civil proceeding, there are expert witness opinion that need to be submitted. There are expansions of complaints that need to be answered. And then in November, the 8th District Court decided this matter, right? Yes, that's right. It issued a final judgment. That is a date, and that is correct. Okay, so these situations happened in 200/2016, and this led to the judgment by the 8th District Court. Yes, that's correct. And the term for this was from 2016 to 2017, and you mentioned the months as well. Let us now look at C34. This is, of course, Contract A21. And let us now look at page, let's see, I think it's 86. You are going to see here 46.2, and this is an arbitration clause. Basically, it says that the parties decided that if the need arose for a dispute resolution procedure, then the rules to be used were the CCI rules for arbitration purposes. Yes, that is correct. That is what was agreed upon on Clause 47. You are an expert in commercial arbitration. You're the leader of the arbitration practice in Galicia, and you have more than 30 years' experience in civil, commercial, and arbitration cases. Is that correct? That's correct. If Drake Finley had been your client at that time in 2016, would you have told them about the existence of this clause in Contract A21? Are you asking if Drake Finley would have told me, or if I would have told Drake Finley? Let me rephrase. If you had been the lawyer for Drake Finley, and Drake Finley would have told you, I would like to start a case against Pemex under 821, would you have told Drake Finley of the existence of this clause, 47.2? Well, I don't know. I think I explained this in my answer. My question was very simple, sir. You indicated that you were going to tell the truth here at this hearing. My question is very simple. On the basis of your arbitration experience, if Drake Finley had been your client, would you have told Drake Finley that Contract 821 contained an arbitration clause? Is that correct? I don't know. If you allow me to explain, I can tell you why I tell you I don't know. You're asking me whether I would have told Drake Finley this. You're asking me to put myself in the shoes of someone else and talk about a conversation that I may have had between a client and myself. Perhaps the client came up to me and said, okay, what are my options to resolve this dispute? I would have said, okay, one of the options is clause 47. You can go to arbitration. Another option is to try to go to the courts, and we're going to see what Pemex's response is. You have a number of options. Okay, thank you so much for your answer. You can continue your explanation later. But you said that you would have at least told your client of the existence of the possibility of starting a commercial arbitration. Sir, I was talking about an imaginary conversation when a client comes to me and says, what are my options? But perhaps I can have other instances with another client that comes to the office and said, okay, I know that I have an arbitration clause in my contract, but for whatever reasons, the client says, I'd rather go to the courts. What are my options by going to the courts? Then I wouldn't tell them about 47.2. I don't want to base things on assumptions as to what I would do or not do when I do not know what the initial conversation was between Finley and the counsel that dealt with these matters. I don't know what Finley asked of those lawyers, and I don't know what those lawyers answered Finley. That I don't know. If a client comes to you and the client does not know that the contract that is showing to you for analysis contains an arbitration clause, you would tell the client about this, right? It would have to do with the review that I make with a client in connection with substantive and procedural matters and the issues in discussion. And I would make a decision in connection with the specific circumstances related to each client at each point in time. Do you know who provided advice to Drake Finley in connection with 200-2016, the case against PEP? I don't know. I don't know who the counsel was that led those cases. Okay, I think that you were here during this arbitration, and you heard the testimony of Mr. Kernion. Is that right? Yes, I heard the testimony of Mr. Kernion. Let us now look at page 38. This was on Tuesday, and the tribunal asked Mr. Oseguera Kernion in connection with this arbitration clause that we just saw a moment ago. And he said that the first time that he heard the word arbitration was in connection with this investment arbitration. If you had been Drake Finley's lawyer, would you have told your client in that hypothetical of the existence of this arbitration clause? Again, I'll go back to the answer I gave. The discussions that I have with each client depend on the issues. I am not a fact witness here. I don't know if the discussions that they had with those lawyers only had to do with the conduct of Mr. Kernion or other individuals. I don't know if other individuals knew or didn't know about the arbitration clause. I don't know this. I am here as an expert at this stage in this arbitration. I don't know who discussed what, why things were discussed, and I don't know if this answer by Mr. Kernion had to do with the only conversation that he had at that time with the counsel. That I don't know. Thank you for your answer. Both Pemex and Drake Finley were able to bring a number of remedies under Proceeding 200-2016 in connection with the review of the arbitration. They were able to bring remedies in connection with the jurisdiction of the judge of the 8th District Court, and there were discussions before the Mexican courts in connection with the payment of court costs because Drake Finley had to pay under court order court costs. Am I correct in this general explanation? Well, I don't know when you're saying you. I'm asking you too when you prepare your expert reports, but you in particular when you examined the civil proceeding. Well, you were saying that you brought cases. No, we didn't bring any cases. That's what I was trying to say. The parties to the proceeding, once they received the judgment we saw a moment ago, they brought a number of remedies And then, after many months went by, they obtained an overturning of the amparo proceeding. That is correct. It is also correct that there were a number of amparo cases that were brought mainly by PEP to obtain the payment of court costs.
Gracias. Te quiero mostrar.
I would like to show you now R49. This is a decision that, in connection with Amparo of 2019, A75 of 2019. Do you remember it? No, because there were several direct amparos, and we're talking, this is November 2019, that would be one brought for costs, correct. We're going to look at page 2. You will see on the screen, and we highlighted it for you, that it was dismissed as extemporary. My question to you is, the fact that an amparo proceeding is dismissed as extemporary, does it mean that the appellant did not present it within the term? Well, the name speaks for itself. It is an amparo that was presented, and it was not within the 15 days for this type of remedies. And I should clarify that this was for costs. It was cost related, and clearly was dismissed as extemporary. And considering your experience with civil commercial proceedings, the fact that a remedy was presented in an extemporary manner, was it negligence by counsel in charge? Once again, please answer yes or no and then explain. I would say no because of the following. This is not negligent, and let me qualify my answer for everyone's clarity. I didn't say that it was negligent. I didn't say that you were negligent. No, but to qualify the answer. There are several reasons why a pleading may be presented in an would be presented timely or extemporary. And the many reasons I can imagine go from, for example, some issues with the attorney, the way it was handled or not, or, for example, some clients had issues obtaining a signature from abroad, and once the pleading is presented beyond the deadline. There are many reasons, but we need to have the knowledge, the information as to what was the reason why the amparo was presented extemporaneously in that period for declaring costs in favor of Pemex. Based on your experience, have you ever, during your professional career, presented an amparo proceeding in an extemporary manner? I do not recall everything that happened throughout 30 years, my 30 years of career. I do not recall any, but I may recall, there may have been a case in which I was not even able to present a pleading due to a problem, for example, the signature from a client or something of the sort. In this specific case, the plaintiff, Drake Finley, presented beyond the deadline an amparo, a constitutional claim. Throughout your professional career, at some point, have you ever presented an amparo proceeding in an extemporary manner? As I mentioned before, I have 30 years of careers in presenting pleadings, cases, 20, 25 years. In some cases, I was unable to present a pleading, and maybe if I have 15 days, instead of presenting it on the 16th day, I do not present it because I wasn't able to obtain, for example, the client's signature. It may have happened. Let us look at the annulment proceeding 2017. There have been two relevant proceedings in connection with contract 821, and one of them was the annulment proceeding in 2017. As far as I know, yes. I'd like to ask you another question. We had already discussed this, and I think that this is relevant for the record. The administrative rescission of 821 in August 2017 was an administrative act, correct? Yes, it is considered an administrative act. And you, and I can call you an expert on administrative law, correct? Correct. And you, as administrative expert, could you please explain that based on the federal law on administrative proceedings, any administrative act is valid as long as the lack of validity has not been declared by an administrative authority, correct? No, I said that it's assumed to be valid. So you are stating before this tribunal that according to Mexican law, administrative acts are only understood as valid. Yes, they are understood as valid, assumed to be valid. Okay, noted. Mr. Bonfiglio, I don't think I understood your question. And you don't seem to be satisfied by the answer. What was the scope of your question? It is striking, Mr. President, because under Mexican law, administrative acts are considered valid as long as there is a decision that states the opposite. And for the third time, Mr. Amezquita has said that it is assumed, they are assumed to be valid. This is substantive under administrative law because it's striking for him to use that word because he's before an international tribunal. First, this is for my knowledge, at least in Spain, the word, what he said is exactly what you asked. So it's assumed to be valid unless it is later on declared invalid. So I don't know what presumption means to you. I understood that it is valid unless a tribunal states otherwise, and that is the presumption of validity, but I don't know if presumption in Mexico has a different meaning. The question I asked, and I thank you for that clarification, Mr. President, the question to Mr. Amezquita, and we might be using different words for the same purpose, but they are considered valid unless stated otherwise. They are presumed to be valid. Therefore, the administrative act is enforceable. If tomorrow it is declared null, you can go back to the facts until the day it was taken. So, in September 2017, claimants initiated the nullity case 2017. I think that I should take this date as valid. I would like to refer to the 2017 case and what the petitioner mentioned. So in an annulment case, we have different statements of annulment. Could you please refer to what it means? Well, it refers to a grievance, so it is an argument. So what the claimant is trying to explain is that what is considered as part of an administrative case, that is to say a violation of their rights, there is reference to different regulations or laws that may be the basis for their dispute, and then they try to reach a decision. So the tribunals, the court says that there shouldn't be just one single formula as to how to develop the challenge principles, but it has to have a clear cause, the cause for requesting something so that the court is compelled to answer the petition by the party. I thank you, and you will see R44 on the screen, and this might be obvious, but I need to ask you, for your analysis, did you consider this document? Yes, I did. And you are familiar with this whole document, correct? Yes, I read it. I would like to show you some pages, page 29. For the record, this is 29. we're going to see, it's my mistake, page 26, I apologize. Here we have the beginning of the basis for challenge. Yes, this is what we read in the headline, in the heading. So, but you analyze the document, so you'd agree with me that this is the expression of the concepts for the challenge by Drake Finley, correct? No, the basis for challenge as a requirement of the claim according to the courts, are not limited to what is stated under a chapter on challenge. The tribunal or the court, according to 50 under administrative proceedings law, needs to analyze the full text of the claim. If there is a claim beyond this chapter on the basis for challenge, and this is clear that a party is trying to present, it should be taken into account, including all of the documents that are attached to the annulment proceeding need to be considered by the court because they are part of the claim. That's why I said that there was no sacred formula as to how to challenge. I may have misspoken. Starting with page 26, and if we scroll down, we're going to see about 9 bases for challenge between pages 26 and 51. You must have read them. Yes, I don't remember how many they are, but I take your word for that. Well, believe me, they are 9. Okay. None of these bases for challenge state that PEP fabricated a work order, correct? I do not recall from the text of this claim that we find the word fabricate. I understand that they presented some facts that led us to believe that there was an attempt by Pemex, by the authority, to cast a potential rescission ground. I do not recall using the word fabricated or false. It was a striking word, and you would have been able to identify it from your analysis, correct? Once again, I do not recall reading that word in the text of the claim, but I do have the impression that because of some circumstances there stated, it was indicated that the work order was not real. There was an attempt to fabricate an alleged work order. Yesterday, a stronger word was used that was sort of fraudulent without using the word fraudulent. So I think that it is too much. My question is, I apologize. Please do not overlap. I apologize. Go ahead. During this hearing, we have heard the word fraudulent, fabrication, false, fake. My question is very specific, very clear. Throughout these 9 bases for challenge, when you analyze them, did you find these words? Once again, I do not recall reading the word fraudulent, false, or even fabricated. I do not recall that word. I may understand from the facts there stated that in context, what claimant tried to say was that there was no material content to that work order. It was issued without the clear intent to be fulfilled, because it was impossible to fulfill because of various circumstances. In some of these bases for challenge, Drake indicated that Pemex had breached with the obligation to obtain permits and authorizations by the Office of Hydrocarbons. I am not certain whether I read it in this document, but I am certain that there was reference to that that there could be an omission in the permits, even with the proven fact that Pemex was stated that the budget was insufficient and there could have been a violation to permits and authorizations that under the law Pemex needs to obtain for a contract of this magnitude. My question is, you don't recall, or this is not included? I recall reading it somewhere in the record, on the record, but I don't remember if it is here. Once again, I do not recall whether I read it here or somewhere in the record. But you would agree with me that none of these 9 bases mention 15R of Contract 821 and the need to breach 15 work orders to decree administrative rescission. I am almost certain that it is not the case in this document, but I saw that during some part of the proceeding there was reference to 15.1. And is that part of your report? No, that was not part of my report because I didn't see it. Is that document part of this record as far as I understand? Or as far as I know, yes, it is included in the procedural record before the Federal Administrative Court. That was not my question, Mr. Amezquita. My question is the document that you are referring to, that you said that you analyzed, that refers to 15R. Is it included on the record of this arbitration? I do not know. I do not know whether it is part of this record. I saw it. It was shown to me, but I was told that they were looking for a stamped version of that document from the court's docket. Now, based on your analysis of the annulment proceeding of 2017, and as we see in this claim, did you see any reference to Clause 15R for Contract 821? In principle, I did not, and in my opinion was that it was not necessary to be able to analyze it due to completeness, as I mentioned before. Thank you. Let us now look at RZ39. October 4th. October 4th, 2018, the Federal Administrative Court decided on the annulment proceeding. That is to say, within a year, the rescission of Contract 821 was validated, correct? Yes, if my memory serves me right, yes, that is the date. So, in addition to the presumption of validity for the administrative resolution, the administrative court confirmed the rescission of Contract 821. Yes, they declared valid at first instance the resolution on rescission. And now, given this, was it necessary to bring a direct amparo before a collegiate court? Yes. Now, Drake Finley, and according to this judgment by the administrative court in January 2019, brought a direct amparo that at the end of the day became 74 of 2019. That was heard by a multi-judge court, correct? Yes. I asked you about the basis for challenge as part of an annulment proceeding. And now my question is, if we're talking about amparo, what is the basis for noncompliance? A basis for noncompliance is an argument that is intended to show that there is a breach of a constitutional nature. In the case of direct amparo, the inconstitutionality arguments need to be derived from the analysis of an award, a judgment, a labor decision, or it could be the case that that articles and legal concepts are analyzed as they were studied to analyze the judgment. Now, under Mexican law, the party that presents an amparo is known as the amparo petitioner, correct? And the amparo petitioner has to base their petition on a legal standard, correct? So no. So you are stating before this international tribunal that they do not have the obligation? No, they don't. You talked about basing. The obligation to base that belongs to the authorities, not to the individuals. Now, when an amparo petitioner is alleging violation under an amparo, that party has to show the law that was breached by the party that is being studied in this amparo. No, according to the case law, the court wants to have a clear claim. That is to say, if I have a problem in the area of health and I do not have access to hospitals or to the public health system, as long as I explain that or present that claim, the tribunal completes that and resorts and invokes in the judgment the individual guarantee that determines what has to be done to grant that amparo. I am not compelled to cite an article, or if I make a mistake, the tribunal can determine what article it is. I misspoke. Whenever an amparo is presented, the amparo petitioner has to explain what right was impaired. Well, I think that you're being too demanding. The purpose of our amparo is quite noble. So you need the minimum amount of formalities. What has to be identified by the amparo petitioner is the grievance that is being the subject matter of the amparo, and the court has to determine the human right that is being violated and where in the Constitution or in an international treaty signed by Mexico on human rights we can find the relationship. Thank you. So at least the amparo petitioner has to determine where it is provided for. As I mentioned before, we need to have a clear cause, a clear purpose for the request. Please tell me the facts that the tribunal will give you the rights. I need to be clear regarding the events, whatever is impacting on me, so that the tribunal, the court, can give me the right that should be applicable. Thank you. We're going to look at paragraph 57 of your first report. You can also see it on the screen. (57) For the record, this is paragraph 57 of the first report, Zamora Mezquita. I have a very simple question for you. As part of an amparo claim, can you enforce bases that were not stated in the original claim? In principle, no. Let me explain. Not in principle, but the rule is not an absolute rule. Let me reiterate. It has to be stated. What we need to state at the very beginning, what is the reason for the request? If you're letting me know that the reason for the request is clear, but I didn't say that it was R15R, for example, as long as the reason for the request, even though I have not cited in particular the paragraph, I cannot be told that I am enforcing a novel principle. Because of the principle of completeness, the court has to analyze the full provision to determine whether the authority acted according to the law or not. Let me ask you the question again. There you see paragraph 57 of the first report that you drafted with Mr. Zamora. Yes, at paragraph 57 you indicated that the amparo can only refer to issues that are presented to the lower court. You recognize that? Yes. So going back to the initial question, so you can only enforce those bases, the same basis from the original case, correct? Issues like this? Yes.
Now let us turn to R55. I'm sorry, it's R50. Now, the Federal Administrative Justice Court issued the nullity judgment, and Drake, in the case of Drake Finley, issued the annulment. Let's go down a little bit. On the screen, you'll see the judgment in Amparo 5410/19. Do you recognize this document? You say that's the resolution of the direct Amparo? Yes, I read it. Now let us turn, please, to pages 39 and 40. On these pages, 39 and 40, one can observe that the multi-judge court determined that Drake Finley's arguments were inoperative because they were novel and because they were not they were new and they had not been raised in the nullity proceeding of 2017. That is the conclusion reached by that multi-judge panel. So here they would say that until Drake presents 54/2019, where it alleges that the administrative rescission would become operative only once there were 15 work orders. Correct? Yes, that is one thing that it said. But this argument was not put forward in the basis of challenge of the 2017 annulment proceeding, correct? The issue was mentioned, the specific reference to 15(1)R, no, in the claim. Now, administrative law is strict law, correct? For the authority, yes. Now, you have told this, have you told this, are you telling this tribunal that administrative law is not strict law? No, the one who has to show that its acts are properly grounded in a provision, that is to say, that has authority, and that some article or clause authorizes it to act in a certain way is the authority, not the private party. I remind you that the authorities can only do that which is expressly allowed by law. Private persons can do all that is not expressly prohibited. For this reason, in an annulment proceeding, which is subject to later review, in a direct amparo before a multi-judge court, what the court does is review the regularity of the way in which the authority proceeded. What does that mean? Whether the authority, based on the resolution it issued, whether the grounds that it cites allow it to have acted in a certain way. That has to be analyzed exhaustively, and that is what the principle of strict legality refers to in administrative law. Fine, this takes me to another point. In your reports, you have said here this morning as well, before this tribunal, that in matters of strict law, suplencia de la queja, which is the court making up for the arguments not put forward by a party in amparo, is subject to that. Would you say that the principle of strict law does not apply to this? What is this concept of suplencia de la queja? Could you please explain it? This is a concept that derives from the fact of there being an irregularity in the way in which the concept or the basis of the violation or the challenge has been drafted, depending on where one is, which forum one is in. For example, failing to cite a legal precept or even misciting some article or section or even a total omission thereof. For example, there are different ways in which an amparo court can make up for the shortcoming in the complaint. Now, in terms of jurisdiction, and this is only for administrative law, it is the authority that is obligated to show that it has the authority to act in a certain way. The Federal Court of Administrative Justice, even if I have not ever mentioned an article with respect to jurisdiction, and even if I did not put forward any basis of a challenge in terms of questioning the jurisdiction of the authority, the tribunal is under obligation sua sponte to analyze whether the articles on which the authority relied were sufficient for authorizing its administrative act. Thank you. A couple of questions. What you say, does that apply just in respect of jurisdiction or generally? Just with respect to jurisdiction, I was pointing out the different degrees to which an amparo court can make up for shortcomings in the argument. So the tribunal has to sua sponte establish its jurisdiction. Yes, it has an obligation to do so even if the private party has said nothing about it. And here you're not talking about an amparo, you're talking about a normal remedy. I'm speaking only of an annulment proceeding and an extreme situation in which a court has to review something even if the issue is not even raised in the complaint. There are other degrees. What is said in 50 of Article 50 of the law, the Federal Administrative Procedure Act, and this is an order, it tells the court how it must act, is that so long as what is being sought is not made clear, the tribunal can apply the applicable law. The only thing it cannot do is change the facts that have been put forward in an argument. That's the only thing that the tribunal cannot invent. Let me interrupt you for a second, because the question of Article 50 is going to come out later in more questions. So in order to not interrupt the cross-examination, let's leave that for later. Thank you, President. I'd like to quickly show you R52. This is the Amparo law. No doubt you're familiar with it. Yes. If we can turn to Article 79 on Amparo, this principle of making up for the shortcoming of the complaint does not apply. Yes, it does apply in situations of Amparo. What is different in the Amparo law is to what extent one can do so. And based on this article, in administrative matters, this principle of making up for the shortcoming of the complaint does not apply. Yes, but there is case law by the Supreme Court that says that in those cases in which the court finds that there were violations that left the private party in a defenseless situation, that is, that the private party was not able to make full use of its right to defense because of the authority failed to respect certain formalities, then one can put forward that argument. It's an exception. This is not reflected in the article. No, it's not. I'd like us to go back quickly to Amparo 74 of 2019. And as a matter of time, I'll move a little more quickly. If we can turn to pages 189 and 191 of R51. Do you recognize this document? It's the direct amparo that was presented by the companies, yes. If we go to page 189, you'll see the ninth argument arguing a violation, correct? Yes. And in this ninth argument regarding violation, the complaining party, or the amparo petitioner, in this case Drake Finley, cited the NAFTA under violation number 9, correct? I see that mention is being made, among other articles, of Article 1105 of that treaty, yes. Now, for the transcript, I'm going to put the question to you once again. In this alleged violation, the amparo petitioner, Drake Finley, cited Article 1105 of the NAFTA. Is that correct? Well, I'm reading right here on this page that, yes, mention is being made of Article 1105 of the NAFTA, among other articles that I see cited here. Thank you very much. Months later, this amparo was resolved by the 14th multi-judge court, and through its judgment, it denied the amparo sought by Drake Finley. Do you recall that? Yes, I do. And the judgment on direct amparo can be challenged through an appeal for review before the Supreme Court of Mexico, correct? Well, just as a matter of order, one can, but it's not necessarily subject to challenge. Recall that the only the direct amparo ruling as a general rule is exhausted at the multi-judge court. However, for issues that have to do with violations of constitutional rules, there might be a special hearing before the Supreme Court, but this should only address the unconstitutionality of rules. And that happened in this case. And this leads me to ask you if you remember that in March of 2020, Drake Finley brought an appeal for review before the Supreme Court of Justice, correct? Yes, I have found out that they did indeed file such a motion. If we could now turn to R54. And up on the screen, you'll see that this is the resolution that was sent to the multi-judge that initially took cognizance of this. And if we can turn to pages 5 and 6. There you can see that the Supreme Court confirmed that the claimants alleged a violation of Articles 1101, 1104, and 1105 of the NAFTA as part of the appeal for review 1885/2020, correct? Now, excuse me, just a detail. You told me that this was a resolution, correct? I would not give it that context. I didn't read it. My understanding, and this is the natural proceeding before the Supreme Court when there's a special review, is that the President of the Supreme Court rejects it from the outset. The Supreme Court does not even begin any review because either it doesn't meet the requirements for being admitted by the Supreme Court, or it is not, the matter is not so important or transcendental for the national legal order. I need to stop you right there because I'm very struck by what you say. You're telling me that in your analysis of administrative law, administrative litigation, and an amparo proceeding, you did not think it. I was not given that resolution. The attorneys for the claimant did not give you this judgment by the Supreme Court. I did not have it. And that is why I make this remark. That resolution, as you call it, I would say it's more a procedural agreement because, first of all, a special appeal is not processed but dismissed. I understand that the Supreme Court did not allow it to go forward because it was not of sufficient importance or transcendence for the national legal order. There was no resolution. But you know that in the direct amparo 74, 2019, and in this appeal for review, Drake Finley put forward arguments based on 1105, as we on the screen, right? I'm aware that it cited some articles of the NAFTA, among others. That's enough. Thank you. Mr. Zamora, now turning to you. You head up the arbitration and litigation practice at Galicia Abogados. Is that right? Yes, it is. Can you tell us whether in your more than 30 years of professional experience you have met with judges or others to explain the position of a client who's participating in some litigation? Yes, as my colleague mentioned in his initial presentation, the practice of ex-parte meetings, alegato de oreja, or de oída, we call it, is a practice which I believe should be abolished in Mexico, and we've made efforts to eliminate it. For example, the new National Code of Civil Procedure, it is eliminated, yet to this day it is a practice with the limitations mentioned by my colleague in respect of administrative law, which is to say well, in the meetings between an authorized lawyer in a matter and a judge is a practice in Mexico. You have done so? Yes. Same question for you, Amezquita. You are the head of administrative litigation at Galicia Abogados, and you have more than 30 years of professional experience, correct? Yes, excuse me, I was sitting back for just a moment, but yes, that's right. We still have a few more questions to go. Go ahead. In your more than 25, 30 years of professional experience, have you met with judges and prosecutors to put forward the position of some client of yours in some proceeding that is underway? Is that correct? It is correct. And adding to what Mr. Zamora said, well, I'm sorry, we're limited in time, but, well, go ahead. During the pandemic, this was one of the main points that was taken up with the judiciary, where we were not able to meet personally with the adjudicators, particularly with the members of the Supreme Court. The members of the Supreme Court, in principle, refused to even have virtual meetings with litigants because this practice is not a right that's enshrined in any law, nor is there any obligation for adjudicators to receive litigants. But to date, even members of the Supreme Court, and this is a voluntary matter, it depends on each one, it has been possible to hold such ex parte meetings virtually, electronically. Indeed, I would not be surprised if they are filmed or recorded, but always with these fundamental principles: not give undue advantage to either of the parties, nor can they be given some foreshadowing of some result. Thank you for your explanation. I understand your answer is yes, you have met with judges. Correct? Correct. I'd like to show you paragraph 147 of the reply brief put forward by the claimants in this arbitration. As you can see here, the claimants indicated that Mr. Keosean and Pauyada met with a judge in representation of the claimants. Had you seen this before? I have heard about these supposed events. Okay, I'd now like to show you the transcript from day 2, and I know the two of you were here because we saw you. Let us turn to page 22. Here, basically, Mr. Oseguera Kernion said that Mrs. Keosean and Pauyada met with a judge on behalf of the claimants, correct? You were here. You heard that, right? In effect, like you, we were here. The context that you want to give a witness statement, well, that really goes beyond our expert opinion as to what a person wanted to or did not want to say in a witness statement. But there it is. You heard it that day? Yes, I did hear it that day. Well, that's enough. Let's now turn to page 33. Here, Mr. Oseguera Kernion also testified that Mr. Keosean offered to meet with the judge in charge of the 2017 annulment proceeding. A question for you, Mr. Amezquita. And this is it normal in Mexican litigation for a lawyer to voluntarily offer to explain the case of one party into a litigation to a judge? If he's not authorized to do so in the record, even if he offers to do so, he cannot. Thank you. Based on what we saw in the reply brief, and with the testimony that you were able to hear from Mr. Oseguera Kernion, the claimants have confirmed in this arbitration that someone representing them met with a judge, correct? And this is a question for Mr. Amezquita, please. Yeah, he made this presentation initially. Yeah, could you repeat the question, please? Yes, I'd be pleased to do so. Based on what we saw in the reply memorial, paragraph 147, and what we were able to hear this week from Mr. Oseguera Kernion, it's our understanding that someone met with a judge on behalf of the claimants, correct? That is what I heard and what they're saying here. Okay, thank you. I'd now like to take you to the first report that you prepared. It's paragraph 189. Here, in very crystal clear terms, you indicated that Pemex had ex parte communications with a member of the Court of Administrative Law, and you concluded that such ex parte meetings would be in violation of codes of ethics having to do with the Federal Administrative Law Court, and that they violate due process, correct? Now, let me indicate, I didn't say that in this case necessarily. I said that any ex parte communication based on the facts that were discussed with me or that supposedly, allegedly happened, that would be irregular, and it could be a violation of the ethics code of the court. Who told you that? The parties informed me that there was information that perhaps an interview had happened in at a certain point in time. Well, the parties here are the state of Mexico and Drake Finley and the other claimants on the other side. I understand from what you just said that the claimants told you that someone from Pemex met with a judge on the Court of Administrative Law, right? When I was asked to give expert testimony on administrative litigation issues, I was specifically asked to give my opinion on the regularity of the existence of ex parte meetings, and I was told that certain things had happened in a certain way, as has been recounted in this hearing by different parties, that had that happened, it would be illegal. It would be in keeping with the custom of ex parte meetings, or it would have violated some legal precept. No evidence is cited in paragraph 189, is that right? I did not have any evidence before me. I was simply asked, if this happens in these circumstances, is that regular or irregular? Is some rule of law violated? And you considered it valid so as to come up with this conclusion. Based on the hypotheses I was given, I drew up this statement, this paragraph. You based your opinion on hypotheticals? Well, I was told, are there ex parte hearings? What does that consist of? Well, this is what it consists of. If there's any matter in which any third person comes forward with a judge who is in charge of ruling on a matter, is that irregular, yes or no? No. Is it a custom in the ex parte meetings for an adjudicator to give early notice to one of the parties on what the final ruling would be? You, Mr. Somoto, also drew up the first and second reports. Same situation. Did you consider as valid the arguments that were given to you by the claimant so as to reach this conclusion that someone on behalf of Pemex met with a judge of the Federal Administrative Law Court? Is that right? I think you're presenting it incorrectly. Let me explain. We, as experts of Mexican law, what is put to us is what are the rules in the wake of which something might have happened. We have no personal knowledge about what was or was not said at the hearing. We're not fact witnesses, but in the face of different scenarios, what is the practice in Mexican law in general, without looking at any of the particulars about who would it be, what was it about, what persons went? No. What is the practice in Mexican law as regards ex parte communications, and what is put forth in this part of our expert report is what is the practice that ex parte communications are allowed with the reservations I noted and the changes in the legislation, and certain particularities are established in the case of codes of ethics for administrative courts as regards certain regulations or impediments that there must be when it comes to engaging in such ex parte communications. It's not a question of considering a given situation good or bad, or considering what some or another person said as valid or not valid. We're not how any particular situation came down goes beyond our expert opinion. Our expert opinion simply looks at the general practice without addressing a specific case, talking about ex parte communications in Mexican law and the regulations that should be applied there too. What evidence was shown to you by the claimant to reach this conclusion that somebody from Pemex met with a judge? It's a very simple question, and then you can clarify your answer. Or the claimant can come back to this on redirect. It's a very simple question I'm putting to you. We did not need any evidence in that what are being indicated are scenarios that may or may not happen. We're not saying that it happened. We're not saying that communication of the 15th or the 18th or the 30th. It's rather what are the general rules and the general practice for communications of this sort between attorneys or third persons and adjudicators. You considered as valid the arguments that were given to you by the claimant to reach the conclusion that is set out in paragraph 189 of your report. Is that right? I apologize if I haven't been clear. Once again, what we're saying is we are not considering that fact that something happened as good or bad. The decision about what actually happened as regards the facts at issue in this arbitration do not correspond to Mr. Amezquita or myself. Rather, it corresponds to the arbitral tribunal that is up before us. They're the ones who will weigh the evidence and determine what happened or what did not happen. Once again, we, and I apologize once again if we haven't been clear, is what are the rules that are generally applicable to ex parte communications. Now, just to look at paragraph 191, you cite Mr. Carnian's statement regarding these supposed ex parte communications between Pemex representatives and members of the Court of Administrative Law. This is the only cite I see to Mr. Carnian. You didn't, the one to Mr. Carnian. You didn't cite any other document or any other evidence, correct? Once again, and again, apologies, we have this statement before us, what Mr. Carnian said about what happened, but the purpose of our report is not to consider as valid or not valid any particular situation. It's simply, in light of this, what are the general rules applicable to ex parte communications without getting into how any particular situation unfolded. without, not mindful of any comments during or before this hearing. That will have to be determined by the tribunal. Mr. President, if you can give me just 1 or 2 minutes to review my notes, to look at the time frames and identify the next steps. Yes. And in the meantime, if you could tell us how much time you have left, because what we have on our calendar is just a general indication.
Señor Presidente, bueno.
Mr. President, Mr. Mesquita, Mrs. Zamora, thank you very much. We have no further questions. Of course, we reserve our right, if the need arises, to do a redirect. Yes, thank you very much. Ms. Finkelstein, could you please let us know what is the total time that respondents have used? I can do it after the break, but for the cross-examination, they used 1 hour and 59 minutes. But I can give you the general times.
For a redirect for claimants. So Mr. Porter or Mr. Melsheimer?
Could we postpone this till after the tribunal's questions as well?
Yes, definitely. And particularly because I know that the tribunal is going to raise a number of questions, and probably Mr.
Solo una pregunta, nada más.
A procedural question, sir. I understand that the claimant is not going to conduct a redirect of our examination, but it appears that they want to pose questions, follow-up questions after the questions posed with the tribunal if necessary. That's my understanding, but they're not going to conduct a redirect. Is that right?
You want to postpone, or you just give up the...
We would just reserve time after the tribunal's questions to ask.
Okay, but then what is clear is that your questions will have to be related either to questions from respondent or from questions from the tribunal. You cannot raise new issues except other than those raised by the tribunal or by respondent. So
that's fine. No, then we have no redirect.
Okay.
We would just.
Okay. And then.
Perdón, señor presidente.
Mr. President, I'm so sorry to interrupt, but the redirect is on questions related to the cross. I understand that they will not exercise their right to redirect. They're going to conduct a redirect, quote unquote, of the questions of the tribunal. If that is the case, we would like to have a second redirect, in our case, a redirect, if you will. So procedurally, I think this is very complicated. It's a situation that we don't really understand.
Pero yo creo que en esto hay que tener cierto...
I think that we need to be flexible here. You are going to have the possibility to ask questions based on the questions posed by the tribunal. The tribunal would like to reach clear conclusions out of this hearing and to allow all the parties to ask all the questions that they want to ask. Of course, there are time limits, but the tribunal needs to reach a clear conclusion because the tribunal ultimately is the one who's going to draft the award. 2 minutes. I need 2 minutes just to be able to answer the questions by the tribunal. Excuse me, I didn't understand what you were saying. What do you want 2 minutes for? I need a 2-minute break. I need a 2-minute break so that I can... Okay, you can relax. Yes, you're going to relax for 2 minutes. Okay, we'll wait for you for 2 minutes. 2 minutes.
Take a normal break.
Are we taking a break, Mr. President?
Gotta be très vite.
So I think let's extend this break to 15 minutes so that stenographers can relax as well. And so we are at 11:34, so this will be 11:50.
11:50.
cases together with all the emails and the conversations.
Elsa? Is it Elsa? Yeah. Let it go. Let it go.
We're going to hear so much about it now.
Go ahead.
Well, before we resume we started with the questions from the tribunal. In terms of housekeeping, it's clear from Mrs. Fleckenstein's calculations that both parties have unlimited time because you have something like 4 hours left. So no time restriction. But the practical restriction would be that today, ideally, we should finish with a cross-examination of responding experts, so that for tomorrow, the questions from the tribunal to respondents expert, not to you, might take place tomorrow, not today, if need be. So that's the slack. So for the time being, don't make any reservation for tomorrow for your trips back, because we keep those still in reserve. And now, having said so, and I say this because there will be plenty of questions from the tribunal, and Mr. Pelé will be the first to start.
Thank you very much. Well, yes, the bad news is that contrary to my my habitude, I will ask several questions. Maybe you can answer shortly, but some of them probably not. And I want to make two general remarks first. First, I have noted that both of you were very eager to only answer questions very closely related to the three contracts that you had analyzed. And I must say that sometimes I was a bit troubled, because I think you cannot analyze a contract without having in mind the background, and a contract does not exist in a vacuum. So I will indulge myself to ask you questions concerning the background, legal background. Of course, if you don't want to answer, you simply say, it's not my expertise. This is my first remark. The second remark is that I had some time the impression that you wanted to see us or to make us specialists of Mexican law. Clearly we are not, and I warn you for your answers that you cannot expect that we behave as specialists. And this takes me to first general questions. Once again, if you think it is not your expertise, you simply give up answering. Do you think that you... no, let me ask personal questions to both of you first. Have you ever appeared before an international court or tribunal before this occasion?
At least on my part, thank you. Perdón, voy a hablar en español.
Thank you very much, Mr. Co-Arbitrator. I think that you clarified something, and I think the important thing that we should clarify at the outset. You could answer in English if you want for Mr. Pellet to facilitate the exchange between you and Mr. Pellet. But at least you that have said that you are willing to speak English.
Feel free. Again, I have to listen to the translation, but the interpreters are very quick, so it will only have 4 seconds difference, so it doesn't matter. Really up to you.
Si les parece,
if you see fit, I'm going to continue in Spanish, and if I need to comment something in English, I'd be glad to do it. I think we also need, at the outset, to clarify something, and this is related to what Mr. Pellet was saying. I think we have to talk about the scope of the expert opinions. We were sought to opine on the litigations that took place. We saw that in our presentation. Obviously, many of these issues happen not in a vacuum, but in a set of circumstances and facts. However, that is not a part of the expert witness opinion. And we're going to listen to your questions, and if your questions are within the scope of our expert opinion, we're going to comment on that matter. In connection with your question, personally speaking, yes, I have been an expert witness, and I have appeared in some court proceedings overseas, and also some arbitration proceedings, commercial arbitration proceedings similar to this one. I think I made a comment in this regard during our presentation. I have appeared as a Mexican law expert in two proceedings in this venue. One was Lion Mexico Consolidated v. Mexico, and the other one was BMEX LLC et al. V. Mexico.
Por mi parte,
I have appeared before international arbitration tribunals. This is the first time that I appear as an expert witness. Before, I was counsel for one of the parties, or I have been a member of an arbitral tribunal. Perhaps we give the impression of being very strict and to keep to the scope of our expert opinion. But in Mexico, we are very, very strict when answering questions as an expert witness, and the expert witness needs to answer specifically within the scope of the mandate that he or she was given.
So let us see, because my first question is clearly general in scope. In your opinion, is Mexican law binding to this tribunal?
I understand your question as to whether the Mexican law is applicable to the decision that the tribunal needs to make in this arbitration. Is that your question, sir?
Absolutely.
No.
Again, I think that is not part of our scope. This is not an expert witness opinion on international law or on applicable law or on issues that have to do with the treaties being addressed in this arbitration. This goes beyond our expert opinion.
I was expecting this answer, but then I would go to the public law specialist here, the administrative law. What will be the effect of this tribunal arbitral award in Mexico? This, I suppose, is a legal question for which can be answered by a specialist in public law in Mexico.
In principle, and in accordance with our legislation, the award by this tribunal must be enforced and respected by the state of Mexico.
And what would be its level of efficiency, if I may say so? Above the law, below the law, or only between law and the Constitution?
That is not part of my specialty, sir. I would not be able to answer that question, Mr. Arbitrator.
Okay, maybe somebody else will at some point. Well, then my second question was general one. You have already partly answered, Mr. Zamora. Again, is it your opinion that contracts exist in a vacuum? Can you analyze a contract making abstraction of the general legal framework?
I think that disputes exist in a context. It includes a number of events, circumstances, pieces of evidence arising from all the things that are put to the jurisdictional body, whether it be a tribunal, a court, or an arbitral tribunal. The decision by the arbitral tribunal or the judgment by a court will have to do with the rights and obligations of each of the parties. These things do not happen in isolation, of course. There are other facts that are relevant in the decision made by the adjudicator. There are facts, piece of evidence, and elements that we have analyzed, but I imagine that these things have also been submitted by the parties to the arbitral tribunal in their memorials.
I had not in mind facts, but more, I could have had facts as well, but more the legal framework, the general legal framework, the laws, regulations, etc.
Y en lo que tiene.
I agree. As far as the opinions that we submitted in connection with the civil litigations and the administrative litigations, we analyzed the procedural law that was applicable and the decisions made by the adjudicators at different stages during the proceedings. This does not mean that we conducted an analysis that included all of the applicable legal framework in connection with public procurement or public contracts or energy regulations in Mexico.
Thank you. Again, as I think I said yesterday, I suppose you were in the room, I usually do not take note. I prefer to listen and then I go back to the... Don't think that I am not interested by what you said just because I don't take note. Then, Mr. Amescuta, do you agree fully with what your colleague said?
Yes, I agree. Yes. Many things can happen. You can have many eventualities, and each situation must be analyzed on the basis of its own merits. I think this goes beyond our analysis, and also this will depend on the circumstances as to what the conclusion would be after analyzing something specifically. This matter has a lot of aspects, sir.
Then I will explain to you why I am asking these questions. It is because something you said this morning. You said, answering a question, that you could not comment on clause 15.3, I think, of contract A21, because such a clause was not argued. You said this at 9:34, and you said again something like that at 9:47. So you said, no, I cannot comment, answering Mr. Bonifilio's question. No, I cannot answer because this has not been argued before the tribunal. Does it mean that you were not interested by what was not argued before the tribunal when you make your analysis? I have quoted you.
Yes, thank you very much. Just to try to understand your question, you were saying that I said that it wasn't relevant that claimant had or had not cited 15.3. You said 15.1R. Is that the one you said? Is that the clause that you were dealing with?
It was not on the.
Era la 15.
Sorry, Don? Okay, sorry. So it was at 9:34 concerning, and it concerned clause 15.3, and at 9:47 concerning clause 4 of 804. In both cases, my understanding was that you said, you cannot ask this question because this was not argued before the court. And then I wondered why. Then I had this reaction, but if this gentleman cannot answer a question because it was not argued, I will go with trying to understand what is the necessity to if there is an absolute necessity to argue all and everything, and my reaction is not very surprising, I suppose. This is at the heart of our discussion in large part.
Just to clarify what your doubt is, sir, I'm trying to understand. What you were saying is that there were questions that were posed by Mr. Bonfilio as to whether a specific paragraph of Clause 15 had been invoked. And I said that it was irrelevant whether that paragraph had been invoked or not, this for purposes of the proceedings. And then you are saying that apparently there was a contradiction because later on I did say that it was relevant. Is that what you were saying? Am I understanding you correctly?
No, not really. Well, I am not trying to put you in contradistinction between you and yourself. This is not what I am doing here. Maybe they will do at some point, but this is not my job. What I want to understand is why you were so restrictive when you said, no, my analysis was really to bear upon things which were argued. I am trying to find this the problem is 1 minute is long. Anyway, this is really what I noted you said, and I suppose I did it when you said so, that you could not comment on clause 15.3 somewhere in around 9:34.
Señor Coárbitro.
Mr. Pillay, I think I understand what you were trying to ask. If you allow me, I can explain to my colleague what I understand the question to be, if you allow me to do so.
Although the question was for him because it is what he said. But okay. I can read it. You said yes, that's why I say apparently, and I say apparently because none of this was argued, at least from what one sees in the judgment. So when something is not reflected in the judgment, you consider that it was beyond your analysis. This is what you said. And you said again 3 times. I only noted twice, but...
Sí, gracias, señor árbitro.
Thank you, sir. Yes, that's why I had the question. I thought your question was related to that because of your quotation of clause 15, and I think that gave rise to the confusion, and perhaps my answer wasn't clear enough. This had to do with a series of questions that were posed to me that were leading to the fact that in the annulment proceeding, nothing was said about 15R. And it says that for a rescission to exist, you have to have 15 unfulfilled work orders, because the express indication to rescind is subparagraph S. So what Mr. Bonfiglio was asking was whether it was necessary for that to have been mentioned in the annulment proceeding, and then, when mention was made to that, in the direct amparo, so that the tribunal could have decided, and then the multi-judge court could have decided in connection with annulment, and if a citation of subparagraph subparagraph R should have been mentioned. The claimant, I said, should be very precise when it mentions the clause that is being violated or that is being misapplied. What I said was not necessarily. That was my conclusion. I don't know whether I was precise enough in the references I made to Mr. Bonfiglio's questions, sir.
For Mr. Bonfiglio to answer, to say later on. And this takes me to the last question of this series, but maybe then my co-arbitrator will want to ask more. But I have others, but they are not in the same direction. It is again a rather general question, but I think it is relevant for what we are discussing. Does the dictum curia novit jura applies in Mexican law, both in civil and in administrative law? I suppose a question for both of you, maybe successively.
Si quiere empiezo.
I can begin, sir, if you wish. You talked about this precise dictum, Iuria novit curia, and what we said, this applies in the administrative system. The cause of action, the cause petendi has to exist. And I need to be very clear when I am a claimant in a proceeding to establish the facts so that the tribunal can apply those facts. And in civil law, things are very, very similar. The parties put to the court the facts, and that dictum exists in the sense that adjudicators in civil law cases must apply the law on the basis of the cause of action that the parties have put to it.
And it applies both to the legal, what I call the legal framework, to laws and regulations, as well as to contracts which are given to the court.
I would say that in the civil law, the case law in general talks about applicable law. But if one of the parties were to say, okay, the contract provides, and this is a hypothetical, a payment of 100 pesos, I think that after that reference is put to the tribunal, the court would have enough elements to see that Clause X of that contract provides for that obligation or not, the payment of 100 pesos. The precedents perhaps talk about the regulatory framework more than of contractual clauses in particular, but I think the dictum would apply in the same way. In the administrative field, I think the same thing would happen. But there's an additional thing. When it comes to annulment proceedings, and I'm sure that you have the same provision in Europe, because a lot of what we have in Mexico has been copied from other Latin American jurisdictions and European jurisdictions. What we do have is the fact that the authorities have to abide strictly by the law, because the subject matter of the proceeding is not only included in the complaint and the answer of the complaint. So we do have, of course, the challenged act, but when the authority answers the complaint, it cannot perfect the challenged act or, for example, add other things. So that is why we have the case that exists between the complaint and the challenged act. So when I put my argument as a private party, I need to be very clear as to what acts have caused a damage to me. I do not have to cite articles because the reasons for the application of those articles, that must be put to the court by the respondent authority. So what the court has to do is it has to look at the justifications put by the respondent authority and make sure that the respondent authority has acted within the law. I don't know if I've been clear. It's very similar to what happens in the civil law field, but I think it's important here because we're dealing with a respondent authority.
Well, unfortunately, I'm not a real civil lawyer. I am an international lawyer. But, well, nevertheless, before giving the relay to my colleagues, although I have other questions, a small question which is really related to that. When you bring an amparo, is it compulsory or possible, or not, neither one, to be assisted by an advocate in both? So, or possible, both.
The legal concept of amparo, as Daniel said, is something that has to do with an exceptional protection, that is to say, to protect the human rights of the amparo petitioner. So the amparo applies to a number of subject matters in Mexico. It can apply to, I don't know, the branch of the bank that is across the street. If it's closed down, this can bring about an amparo, or as Mesquita was saying, this could be an amparo brought by an individual that has access to medical services. It could be an amparo brought by a company against a judgment because a certain number of procedures were followed. For example, a non-lawyer could submit an amparo and say, I am Mr. X. I came to this hospital, had a certain illness, I was not provided service, and for whatever reason, I had the right to receive service. And he, without a lawyer, could submit an amparo per se. I don't think that a judge could dismiss an amparo because that person is not advised by a lawyer. The amparo seeks to protect human rights, so it's not very formalistic in nature. It's trying to protect the rights of the amparo petitioner. Administratively speaking, in general terms, like in other cases, for example, in labor law or in criminal law, in amparo law, you do not need the assistance of a counsel. If you are assisted by a lawyer, that person must show that he or she is a lawyer that is able to represent a petitioner.
So, your answer is yes, it is possible not to have a lawyer. It is possible to have a lawyer. Are there any case, and I suppose it could be the case before administrative court or constitutional court, are there any case where it is compulsory to have a lawyer?
Que sea obligatorio contar con un...
That it is compulsory to have a lawyer, administratively speaking? No, it's not compulsory, no.
So maybe you want to go on? I will go back. Don't worry, I will go back.
Antes de que le...
Before letting Mr. Stearman ask his questions, I want to ask something. You said that the case is made up of a complaint and of the challenged act. The aggrieved party must cite the facts that cause them harm, but it doesn't have to cite legal precepts. Now, does it not have to cite contractual clauses? I understand perfectly well what you said in connection with legal provisions, but what about contractual clauses, such as paragraph R of clause 15? Mr. President, I'm going to try and be clear in this connection. There is something that's very interesting here. Pemex, in this case, is the respondent authority in connection with contract 821. And Mr. Bonfilio talked a few days about these powers called the jus in pari, or things that have to do with acting on an equal footing. So Pemex can act on an equal footing with the other contracting party, just like any other private party. But we have talked about these cláusulas exorbitantes. These clauses, these jus variandi clauses, are not common in private law. In this case, Pemex is acting as an authority. When, for example, in the case of an administrative termination, this is an administrative procedure recognized by our case law that ends up with an administrative decision. When there is a decision of this kind, I can bring an annulment proceeding before an administrative court and not before a civil court. One would think that this should have been brought between a civil court, but no, that's not necessary. So this is a mixed bag situation. So against this administrative decision, which is the rescission that is born of a clause, this is, of course, supported by general legislation. This clause is not inventing administrative decision. It is being supported by legislation in this regard. So these clauses, in connection with these issues in particular, are individualized regulations of an administrative nature. Why? Because they are used as optional for Pemex, so that Pemex can proceed and address a rescission. I completely understand. Thank you very much. Mr. Stearman has the floor. You answered one of my questions already. I have one less question to ask then. This issue is interesting to me, and I think this was also asked of you by Mr. Pillay. And this question perhaps is for Mr. Zamora. Now, You may tell me that this is an issue of international public law in Mexico, and this is not part of your expertise, and we can ask other lawyers about this, but is the Mexican system a monistic or a dualistic system? And that is to say, international regulations and norms are part of the corpus juris of Mexico, or it is something separate. This is a constitutional matter, perhaps, or an international law matter. Somebody else can answer this. Yes, Mr. Arbitrator. Yes, these issues are very complex. I would like to have others answer this question. You will have to look at precedents, and you would have to look at the applicable regulation. But the issues related to international law should be answered by someone else. Very well. Then, I don't know if this question is for you, Mr. Zamora, or for Mr. Mesquita. At paragraph 33, I had cited a number of examples, and the law provides that a judgment should be rendered in 10 days, within a period of 10 days. What paragraph? 33 of your statement. And the deadlines are very, very short. You also make reference to a reasonable term principle, JAH 034. If a remedy was brought on the basis of a reasonable amount of time, or a reasonable period of time, and it was decided by the tribunals that the court had not met all the requirements, is that what defines what a reasonable term is? Paragraph 33, I make reference to terms that must be complied with within a certain period of time. We don't have a lot of precedents in Mexico. And along the lines, the comments made by your co-arbitrator, well, I have to say that Mexico is a civil law country, and for many, many years, the system of precedents was not quite developed. Of late, it has been developed more. The precedents are published once a week on Friday, and all of the federal tribunals that can issue precedents in Mexico, we saw that there are many. There's a Supreme Court, multi-judge courts. Perhaps we only get 50 precedents per week. And those cases have to do with health matters, administrative matters, criminal matters, fiscal matters, labor matters. So I look at that every week, and I would say that perhaps we have maybe 10 precedents per week. So the case law development in Mexico is not very substantial. So we don't have precedents that say 10 days is a reasonable amount and 15 days is not. So when I dealt with civil cases, if we look at the first case, the case of contract 803, the term was very long, 5 years and a few months until the case was dismissed. 5 years and 7 months elapsed without a first instance judgment being rendered. So that would be unreasonable, clearly. In Switzerland, which is my jurisdiction, we see that there is a specific remedy that can be brought. It's not a direct amparo, it is an indirect amparo, it is an administrative remedy, and you can complain of delays in the proceedings. I'm not going to give you the technical term in German, but that exists in Switzerland. If you see in Mexico that there are delays in the proceeding, can I submit a specific amparo to address that issue? There are two ways that you can take. As you said, you can file an indirect amparo because there was an undue delay, but you have seen that the deadlines in these amparos, that indirect amparo is going to take 24 months, right? Between 10, 18, or 24 months, depending on the special circumstances of each amparo. So this is a solution that is far from immediate when it comes to delays. The other path that you can take is that you can file an administrative complaint. So you can go to the organs that regulate judges and you can say, okay, this judge is delaying this proceeding that he or she is hearing. I don't think that in my 30 years of practice, I have seen that even if you're successful in your remedy, the judge is going to be penalized. Of course, you don't want to do that because that would be bad for your clients, right? You're always trying to act for the benefit of your clients. At paragraph 91 and at paragraph, well, let's look at paragraph 91. And perhaps this question is for Mr. Maceita. You explain that administrative proceedings started on 5 March 2019 for one of the contracts, 804. The civil case, if I understand correctly, was decided on 18 December 2016, this in connection with 803. And it was decided there that the civil court should hear the case. So the first, it was decided in 803. And then the tribunals decided that the civil court should be the one hearing the case. And then 18/10/2016. Just to be clear, when you are making reference to paragraph 91, you're talking about the administrative proceeding of 804, right? Yes, 804. And I understand that your comment has to do with when the civil proceeding ended for 804 that made reference to 803, but we're dealing with 804. Yes, paragraph 89 contains the date, which is when the collegial court dismissed the amparo and 804 ended, and this is 18 October 2016. Yes, correct.
But I had another question that it was related to this. So why is it that took 2.5 years to initiate the administrative proceeding? From the civil to the administrative proceeding, why it took 2.5 years? Well, I assume that the administrative proceeding before the court was initiated against the termination, in addition to other issues that were challenged from some minutes from the conciliation discussions before the public official. Those were the two claims. I'm not aware with the conciliation or the mediation files, but the conciliation may interrupt the period for the presentation of the annulment proceeding. Once there is conciliation and with the precedent of termination, the annulment proceeding is brought, and usually there is a 30 business day period once the resolution is issued, the latest resolution that is intended to be challenged. So that, in my opinion, explains the delay between the beginning and the continuation of the proceedings, because part of the dispute in the administrative before the administrative court was to exclude some aspects of the conciliation, rather to include certain aspects of the conciliation. This is a question for Mr. Zamora. Paragraph 121 indicates that claimants on March 19th requested the dismissal of the claims. I am not understanding why, as part of the same proceeding, the courts continued to act, and in October there is a new judgment on that topic. Is this a new docket, or why is it that the justice continues if there was dismissal? At paragraph 116, I am referring to a judgment of April 2nd, 2019 that settles the merits of that case. As of that date, basically all of the acts are acts that from the level of the appellate court, Pemex brought several amparos to obtain greater benefits in terms of the actual cost of the proceeding. So the reference was made to that when Mr. Bonfiglio was asking some questions, but everything that had to do with costs. So there is a dismissal for all of those aspects that could be relevant to the parties in that case, but they were no longer proceeding with that. It just had to do with costs. And as you said, at paragraph 122, we have a judgment dated October 21st, 2021, connected to or related to costs, because that was still ongoing. Now, as to the res judicata principle, the decision by the appellate court was only considered final when a decision was issued on cost? No, that decision was independent from the cost decision. The cost decision was something that was being discussed by Pemex, and you can see the numbers at 122, where I am referring to a decision at A98-17, but that the amparo courts are not replaced or do not go back to the tribunal that issued the decision. For example, let's say that I am the defeated party and I go to amparo and the amparo thinks that I should prevail. I am not going to hand down the judgment, but I am going to instruct the lower court that Mr. Zamora has proven or evidenced this or that. And what we call is the game of the amparos. And this is what we see from 2019 to 2021, basically by moving forward to an amparo court where the amparo court says, okay, please review costs. Then it goes back to lower court. Lower court reviews, and then it goes back to amparo. Okay, make new adjustments in favor of Pemex. One goes down to lower court, then back up to amparo. That's why we see all of these decisions since 2019 in connection with the application of costs that Pemex was trying to obtain against the other players. I know that you're talking about a game here, the amparo game, but there is a decision here of April 2nd where there was no evidence of the case. Pemex is not liable. Is that a final decision as of April 12th, 2019? That decision is final upon conclusion of the period to bring an amparo that Pemex brought, but that the plaintiffs did not bring in that case. So then that part is final. That part is final then, even if amparo on costs is presented. That is final and it can be enforced. It is final. I don't know if it could be enforced in practice because it would depend on seeing whether the docket, well, there would be nothing to enforce at that point in time because that judgment considered that the respondent was not liable, but it is final after that date, and then we would have to analyze the procedural characteristics of all of the various cases. I understand that in that case, the tribunal decided that Pemex was not going to be awarded cost. That is to say, they were not going to be compensated, and therefore that led to the amparo. Yes, and all of the other amparos are related to costs. So my first reaction is, don't you think it is normal that a prevailing party that is not recognized costs to say, this is something that bothers me and I want to litigate it? It doesn't necessarily have to be normal. I have clients that are not awarded costs and they do not decide to proceed, and they decide not to proceed. So I wouldn't say that there is a generic rule that all of the plaintiffs are going to go after costs. It has to be seen on a case-by-case basis. But it is not something terrible for me to try to have the costs compensated, right? Well, I would say that it has to be analyzed with other characteristics and determine what would be the right characteristic, what to call that process, but it depends on the case. And if you allow me, what I would say is that the cost regulations under Mexican law, I don't know if it is similar to that of other countries, but it establishes certain criteria that are quite objective when we're talking about a claim that does not have a favorable decision, a favorable judgment. So the judge is not assumed to analyze all of the characteristics of the case to decide on the cost. For example, under the legislation of Mexico City for civil cases, there is a cost rate, that is to say, a percentage of the value in dispute. That percentage says that, for example, above a certain amount, it could be 8%. To give you an idea, the judge does not look into the fact that the prevailing party counsel received an X amount. It is 8% above a certain amount. So what I'm saying is there is no the same analysis that we can see in other circumstances. I need to see whether it was good faith, bad faith, if there was unnecessary evidence. It is not that we don't have that level of depth in terms of the analysis, and the same happens in regular cases. Final question: the res judicata principle, and this is a question for Mr. Zamora, is that part of public order in Mexico? Beyond the fact that it is a concept that is protected by the Constitution, is this part of public order, national public order, or international public order? I am not certain. I would need to analyze the precedents, but I can tell you that based on what I recall, some precedents have established that that could be appealed by before some court. Let me put it otherwise. If I have an award that has been issued, an award that needs to be enforced under the New York Convention, and I allege and I can evidence that the award is a violation of public order in Mexico, and I want to enforce that judgment in Mexico, may I allege that there was a violation of Mexican public order as a defense under Article 5 of the New York Convention? I would think that it is debatable. If a judgment in Mexico says red and an award says blue, My opinion right now is that that arbitral award that is protected by the New York Commission, the Chamber of Commerce Code, etc., may be contradictory with the judicial judgment, and it doesn't mean that it is contrary to public order. The award approves a contract, but I allege that the decision in the award breaches public order because, for example, the concept of res judicata has been violated, so the tribunal would have to apply the concept of res judicata. They didn't do so, and then the other party is trying to enforce that award in Mexico. I may allege or not that the tribunal did not apply the res judicata concept. Therefore, that the judgment cannot be enforced. Well, I have not done that analysis before, but I can tell you that the arbitral award would be enforceable. In this first round, I first want to ask Mr. Amezquita to explain Article 50 of the Federal Law on Administrative Proceedings. I interrupted you, and you can do it now. I thank you, arbitrator. I don't know if someone can put it on the screen, Article 50, because then I am also going to refer to other articles related to 50. So I think it is your report. Article 3 or 4. You can show Article 50 if you want. If claimant would like us to show it, we can do so. Yes. I think it is RZ04. I think that for some, I am sorry for interrupting. What article? 50 of the Federal Administrative Law. This article, Article 50, under the administrative law, is a mandate for the court.
Su sentencia. ¿Qué principios deben?
What are the principles that need to be met in general terms? So, one is the completeness principle. Completeness as defined in general terms as something that has to be decided, that has to decide what the parties request, mainly the plaintiff, that is to say, the party presenting the annulment request. This is whatever has been requested has to be solved. That completeness principle, and also based on the case law we have, could be analyzed by the tribunal, and even though the federal judiciary branches decision are the ones that prevail, or the court may resort to case law. So that completeness principle means that the claim, together with everything that is presented with it, is part of the claim. For example, the analysis by the tribunal on contract 821, and also the authority, Pemex, argued as part of that annulment claim that one of the companies, if my memory serves me right, it was Finley, did not have legal representation because the power of attorney had not complied with the provisions to be met for powers of attorneys abroad. So the court analyzed the power of attorney fully, and they concluded that it did comply with the text of the convention, but most importantly, it told the authority, I see that from the statement of claim, the person that signed on behalf of Finley the claim is the same person that under the contract, that is one of the main pieces of evidence, was signed by the legal representative. And also you recognize the legal representative when you serve notice of the rescission communication. So you already recognize the representation of that party. So the tribunal went beyond what had been said by the company. Finley had only said in their claim, okay, I evidence the legal representation of Finley with the power of attorney. I am hereby attaching it, but the tribunal went beyond this, and this is also mentioned in some ancillary pleadings, but the tribunal analyzed that and also reached the conclusion that in all, and also after looking at the contract and also the communication on administrative rescission, this legal representation was already recognized by the authority, and so you cannot now say that you do not recognize it. This is an example of a completeness review. And another principle has to do with consistency. Consistency based on the case law that we have is either internal or external. External means that everything that has been requested by the parties of you, that is to say of you, the tribunal, you indeed need to include it in your resolution. Nothing else. So you should not be resolving with more or less of what is requested. And also you need internal consistency. What does it mean? That there shouldn't be any contradiction among the various parts of the judgment. There shouldn't be, for example, the case that on the one hand I am concluding one aspect and on the other one the judgment says something different. And the third element, in general terms, that we also take from Article 50 has to do with the reasoning, and this is something that you already have in your own jurisdictions. Reasoning is very important. That is, rather, the first part is the precise citations. That is to say, whenever an authority is referring to a specific case, that is referring to that citation, and then with motivation we have the narrative that has to be quite specific. Why the authority, for example, in the case instant, considered that those articles, those legal principles are to be applied to the case. So with these two elements and based on the case law, if they are met, the individual has all of the certainty on the facts that are presented, and that party has all of the tools at hand to enforce their right and also the right to be heard. This is, in general terms, the umbrella under Article 50, and then we tried to bring it down to certain irregularities that we did see from our own point of view that were incurred by the tribunals that heard these in these cases. Very well. Thank you, Mr. Amezquita. Now I am going to ask you a second question in connection with something that you said at the beginning of your presentation. If I heard correctly, you said that in the contract, and we were reading a clause in the contract that I think had to do with suspension, you said that even though the literal meaning was may, since this was an administrative contract, there was a need to interpret that even though it said may, the meaning was that PEP should. So I just wanted you to offer other details for that interpretation, since this is an administrative contract. There are some clauses that need to be interpreted beyond its literal meaning. Yes, I know what you're referring to. we go back to the very specific mixture that we have in Mexican administrative law and public contracts, and how to separate public from private, what is administrative and what is of civil nature. This principle comes from our administrative law, that is, proceedings. In particular, this is a result of sanction imposing proceedings under the law. Whenever an authority initiates a proceeding of an administrative nature and the law provides for each of the stages, conditions, requirements for the administrative proceeding, we are faced with a regulated power. Now, whenever there is some discretionality for the authority, that is to say, the authority has some room to maneuver to make a decision or the other, we have discretionary powers. And then as long as general concepts or evidence is offered as a motivation for a resolution, that is fine. But in some cases, they may not be allowed. For example, if we're thinking of an administrative rescission, the precedents that we have start with the regulation under the laws as to how the proceeding will evolve towards rescission. We also have some development for sanction imposing proceedings. For example, a relevant proceeding to try to illustrate this is that in a sanction imposing proceeding against the stock exchange, the Mexican stock exchange, if the law establishes as part of the sanction imposing proceeding that the party indicated that there was no intentionality, that there was no damage caused to the market, etc., etc. That is, there is a maximum of mitigating circumstances. Instead of imposing the minimum penalty, the authority may just admonish the party. So the analysis by the Federal Administrative Court in this connection against what the authority during the case had said is that the word may gave the Mexican Stock and Exchange Commission to choose whether in each case they were going to impose the minimum fine or just admonish the party. The tribunal reached the conclusion that whenever all of the mitigating factors are present, may is to be understood as should, because it is a regulated power, and I need to offer the greatest benefit to the party. I am here faced with all of the mitigating factors so that I do not impose a sanction. This administrative rescission proceeding under the law is an administrative regulation that requires a regulated power, that entails a regulated power. That is, the meaning of what we are reading has to be understood, and we can understood it as the may becomes a should based on these precedents. Here we're trying to apply a clause, but this clause provides for an administrative rescission. Therefore, it is providing for an ad hoc proceeding in the case of this contract, and therefore, according to our own precedent, it is of an administrative nature, so much so that the product of that proceeding may be taken to an administrative court rather than a civil court. I know that all of this sounds a little bit crazy, but I have proceedings under the same contract of a civil nature, and others that are administrative in nature, at least in terms of the jurisdiction that the court has. And I also have some authority acts, such as a work order, that is an act that we could consider of a civil nature under some provisions under the contract. But the administrative rescission is an act of authority, even though it is in a clause under the same contract. By following the same line of thought, this clause provides for an administrative proceeding, and if we are to apply the precedents to other administrative laws that govern rescission, this is a regulated process. And as part of this regulated process, there is the word may. We may say that it should be read as should or shall. My feeling is that this goes beyond the word may or should, because also under the same contract we have a good faith clause. And under the principle of good faith, as defined even under the contract and in our case law from the administrative point of view, it should be understood as a collaboration between the parties. That is to say, a desire not to cause any damage and unnecessary damage to the other party, and also trying to have the compliance with the purpose of the contract prevail. This is the most important aspect based on our case law and the administrative good faith. Here, the idea is to comply with the purpose of the contract, because it is not any purpose. It is not for the benefit of an individual. It is for the benefit of the community. So whenever we have this public contract, we have a public need and a public necessity, and that's the reason why parties need to act in good faith to comply with the purpose of the contract.
So in addition to saying that one could interpret may as shall, I need to carry out the purpose of the contract, even if it's after the time for doing so, even if the contractor is going to incur more work and more costs. The idea is that the contract survives. This does not free them, according to the very clause of the contract, that does not free them up from there being a contractual penalty. But if it's possible to afford them the opportunity to have some extra time to cure some alleged non-performance, then in principle that should be done. And I repeat, not only because we can consider that it is a regulated procedure, a regulated power, but also because it is inconsistent with the idea of good faith in administrative law matters. Thank you very much, Mr. Amezquita. And the next question I will ask you is a bit related to the previous one. In your previous words, you said that you did not know where, but you thought you recalled that in the complaint in the administrative proceeding, the claimants had said that PEP, you said, had sought to sow grounds for administrative rescission. I understand that this is a very similar reference to what the claim in this arbitration, what the claimants have called a scheme to rescind the contract. So for any European jurists, and all three of us are, automatically there's a concept which has not been cited in any document, but which automatically comes to mind, which is the concept of, and this is based on the influence of the case law of the Council of State of France, that is called abuse of authority or deviation of authority, and that is using an administrative power to pursue an aim other than what justified that administrative power being granted. I don't want to get into a lengthy explanation of the concept, but one of the judgments of 1872 of the French Council of State casts a lot of light on this. France had lost the Franco-Prussian War, the Ministry of Finance needed money, and it occurred to them to expropriate the certain factories that were very profitable at that time. And in order to reduce the cost, the Minister of Finance decided to issue instructions to the prefects of the different regions to shut down the factories, arguing that they were match factories, arguing that they were against health provisions. And so they shut down a fabric so as to be able to then buy it cheaper. There was an appeal, and the Council of State, which in France had decision-making power, annulled the contract, and in that judgment and many others, this concept came about of abuse of authority or a deviation of authority or power. And in English, it's often translated as misuse of power, but in Anglo-Saxon law, this concept is not so developed as in countries such as France, Spain. I'm not sure about Switzerland, but it's extremely well known in European law. So now turning to the Mexican case, if someone could go to Article 51 and following, I have seen that at the Inter-American Court of Human Rights, which you cite, the concept of abuse of authority has been drawn on to annul a decision, for example, in the case of Venezuela. But in the Mexican case, I see it, you seem to call it desvío de poder instead of desviación de poder. Well, it is the same idea. But in Article 51, which is the next one, if we go to the grounds for annulling contracts, in Section 5, I think there, even though there is no mention of abuse of authority, it is still there. When the administrative resolution handed down in the use of discretional powers does not correspond to the purpose for which the law confers such powers. So perhaps like the Minister of Finance of France, they're going to have them have the health authorities invoke their authorities to bring down, to shut down the match factories, so to be able to buy them cheaper. So I don't know if you'd like to make a comment on this concept of abuse of authority, but could you be a little bit more precise when you say that in some part you had read that PEP, or that the respondents in the administrative trial had alleged that PEP had sowed grounds for rescission. For I have not seen that argument in the memorial, in the claim, with which to ask an administrative judge to understand that there's been an annulment of Amparo 5 in Article 51 when the claimant hadn't even made any reference to such misuse of power would be asking the judge to be a Hercules who is capable of understanding everything, even all that has not been argued before him, even though they might be able to make up for any shortcoming in the complaint and have the power to read everything. So where is that reference to what we could call a supposed defect of abuse of authority on the part of PEP when it rescinded the contract? First of all, the question of abuse of authority, in effect, in Mexico, we have copied that concept going back many years in our fiscal procedural legislation. So this is the result of an evolution that has unfolded over many years, where abuse of authority has always been, one has been able to argue it as grounds for annulment. It's not argued very often. There are not so many precedents. It's not easy to argue and prove this before the court. But we do have this ground of annulment before the Federal Court of Administrative Justice. Second, what I said was in response to a question that the Ministry of Economy put to me in terms of whether there had been any mention of fraud or some machination, some similar word. What I was answering was, no, I don't recall having read that all of this machination, so to call it this on a provisional basis, that it had been a fraud or anything similar. What I said was that I came away with a feeling that what was being put forward by the companies in arguing their defense was a concatenated series of events, unusual or unlikely, so to speak, that would lead one to think that there was a machination to invent a possible ground for rescission. For example, I think yesterday there was some discussion with the representative of Pemex about the haste with which it was asked that the administrative rescission procedure go forward. Some communications, and I'm not saying this is what they said, but they seem to suggest that one should find whatever so as to be able to justify an administrative rescission. And then we see this clause in the contract. Well, in the event that there were an urgent situation after many months for a work order to be carried out, supposing that were the case, and that because of some situation I did not receive, or rather respond to the call to receive that work order, why don't we consider the possibility of giving ourselves some extra time so as to be able to try to comply with what that work order suggested? So my answer was I never saw an argument that attributed to or that characterized as fraudulent that action on the part of the authorities. Indeed, that private person did not say so in their arguments either. Nonetheless, I come away with a sense that throughout the presentation of the facts and the grounds for challenge, what the companies tried to do was to show that there was an unusual chain of events that were inexplicable, that lacked any rationale or justification, and that apparently go against the spirit of some of the clauses of the contract that would give them to understand that this was a retaliation against the civil actions that had been brought by the companies against Pemex. Okay, so what you're saying, it's a somewhat diffuse sense, because here the claimants at paragraph 73 of their reply memorial clearly say, speak about a scheme to rescind, which in European terms and in terms of that ground 51.5 would be an abuse of authority. But reading the claim, I haven't seen any vestige of that allegation, perhaps because one would have to be a bit bold to invoke this ground. Abuse of authority, as you say, is seldom invoked. And that's why there was an annulment act that was brought by the prefect of Lois, or brought against the prefect of Lois, who had shut down these factories on grounds of health, but it was out of fear, out of lack of knowledge. In the claim, I see no vestige of any argument of abuse of authority, and that is why I think it's a bit excessive to ask the judge, if that's not been alleged, to also get that sense that you have said from the reading. And so even though the claimants haven't alleged it, I think there's been a possible vice that would provoke annulment pursuant to 51.5. Would you see this as an improper act by the judge who handed down the judgment of 2018, or would this go beyond their legal obligations? According to Article 51, if one notes, sir, it doesn't say that the private person has to fit the ground for annulment in one of the subsections of Article 51. Indeed, seldom in the drafting of a basis for challenge does one call for annulment pursuant to Article 51 on the basis of a specific subsection, except for some isolated case where it's asked for certain effects or where one seeks a particular resolution in an annulment proceeding. So in general, you are right. There is no mention in the claims that I reviewed with any argument even remotely related or intentionally related or that directly related to abuse of authority. What I could observe, and this is why I say, well, I agree with you that perhaps it would have been much easier and quicker to come up with a single argument on abuse of authority, but what the private party or these companies did was to attack each defect on its own merits. So, for example, they say, well, when you tried to notify me of the work order, supposedly, you engaged in certain violations because you did not apply, that's what the companies argue, you did not apply the general law and administrative procedure. You should have given me a certain form of notice, sought me out to who knows where, and so on. And then, based on what you did, you tried to do it with a notary, and I find in that transaction with the notary for the notice, I find these elements which violate particular articles, and so on and so forth. So the idea is to dismember a possible, much more comprehensive argument on abuse of authority and segment it into particular violations that took place during the process of giving notice of the work order and subsequently in handling the supposed grounds so as to give way to the rescission. Now, I understand that you're not specialists in international law or the NAFTA, but since this was discussed the first day, what is being put forward here is an allegation of a denial of justice, and the international standard for a denial of justice is that the judge must have acted very poorly and must have been arbitrary. It doesn't suffice for them to have not done their job well. So the standard for denial of justice is that a jurist must find the reading of the judgment repugnant, and not just that, and not a sense of from the whole of the argument. And this leads me to something which we've debated quite a bit. Excuse me, if I may, just to clarify this point, I never said that based on this argument that the courts should have tried to make up for shortcomings in the amparo complaint or to carry out a more complete analysis with this approach informed, say, by abuse of authority. What I said is that from my point of view, with respect to the application or non-application of Clause 15(1)(r) of the contract, which refers to the need to have violation of 15 work orders in order to be able to effectuate a rescission. And instead of that paragraph, the authority applied Section S, the generic one. From my point of view, that analysis on the part of the court was a violation of the principle of completeness. What the Ministry of Economy asked me was, well, apparently, at least in the memorial, that was not, the private party did not cite the existence of Section R. And what I said is that if one were to have carried out a complete analysis, it wasn't necessary, because based on S, if I carry out a complete analysis of that paragraph, which is mentioned in the claim, which was mentioned by the authority in its answer, and which obviously was invoked in the administrative act, or the act of the authority, I need to review in order to be in agreement with the court whether there was compliance with Section S. I need to look at two things, which is to say the general rule which applies to anything else. I need to make sure that the basis for R is not present. And then one would have to have been aware that this paragraph existed. And second, in order for there to be a legal definition of the grounds for rescission, I can't stick with S. I must perforce have to invoke the violation of some other clause of the contract. That other clause that the authority found, what they cite in the official communication and in the answer to the complaint, is the second clause, which speaks of the purpose of the contract, but it does not speak of work orders. Had one wished to make reference to a clause that speaks of work orders, well, we have 6.6, which says that the non-performance of a work order, depending on its nature, will give rise in general to a fine. I was going to ask you the following question on R. I understand your argument perfectly well that the judge, sua sponte, should have analyzed all of the potential grounds, and since there was one that was more specific, R, more specific than S, that they should have applied R instead of S sua sponte. But I have a question. You say that in order to invoke S, one must necessarily have to cite another breach or non-performance. For example, you used the expression shoemaker's box. Well, we in Spain have an expression, the tailor's box. They have a box where they put things in, but I would think that in that box, well, S says what it says. What it read literally, it says that a non-performance is required. One non-performance is required. Why do you say that another one needs to be mentioned, citing B, purpose of the contract? Well, if we look at the paragraph, what it says is any other non-performance of the contract. So I cannot base my act on 15S alone. Why? Because 15S says any other non-performance. Well, what is that other non-performance? Where is it provided for? What the authority says in its decision on rescission and in its answer to the complaint is that the other non-performance are two, mainly not having carried out the work order, and I leave aside for just a moment, but it's also a ground under S, the failure to perform with respect to PACMA. Now, in terms of the principle of completeness, I stick with the first one. Okay, you tell me it's non-performance of a work order. Where is it provided for in the contract that you have to carry out the work orders? At clause number 2, no. The second clause is only the general rule of let us carry out the purpose. Where is it provided for that one must carry out the work orders to tie that to this article or clause 15S? That's my point. But I continue to fail to understand you because in the judgment, the judge says literally that a single act of non-performance suffices for rescission. So according to the judgment, one non-performance of the PACMA obligations would suffice for the PEP to be able to. So I don't understand why you say that another non-performance or breach is required, because when you say the other, well, there's one and the other. The thing is, when we go to the annulment proceeding, in principle, I have to attack everything. It says so in the judgment. Even if you had attacked or challenged the issue of the work orders, if you don't challenge the ground, of non-performance that makes reference to the PACMA, then the rescission is firm. You have to invoke all of the grounds for rescission that were invoked. Well, several were, and several. The court mentioned several, but it proceeded to rescission because of two fundamental things: 15b, and that is attributed to, well, I did not come forward to receive and sign the work order. That is subsection B. Now, what was the defense of the companies? Arguing that they were not given notice as agreed upon in the contract. Had they won on subsection B, from my point of view, there would have been no basis for going on to analyze 15S in relation to the work orders. Why? Because if I show that the authority did not communicate the work order to me as we had said would happen in the clauses of the contract, therefore I never found out about the existence of the work order, and therefore I could not carry it out because I did not know it existed. That was the argument. Now, when the court ruled on it, saying, I'm not convinced by your arguments with respect to subsection B, it said. And so now I will analyze subsection S with respect to the work orders. Now they have their own arguments with respect to the breach of the PACMA obligations. But in terms of the work orders, what the court says is you should have argued specifically about 15S. For otherwise, if you're not upholding any argument, then this rescission remains firm. Nonetheless, right thereafter, the court analyzed the rescission with respect to PACMA. It says, well, I understand that you invoked this in relation to B. I don't agree with you. B had already become firm. And now I'm going to S. And regarding the work orders, you didn't tell me anything because you didn't argue anything more regarding the application of 15S related to the work orders. So the only thing that I'm left to do as the court is to proceed to the analysis as to whether or not the ground for rescission is present for having breached the PACMA obligations. This pursuant to 15S. Therefore, when applying 15S, it has to do so, for example, in the case of the PACMA, in relation to, I think it's clause 48 and its annex. It cites the clause in the annex because those are the references for being able to say, what is that other clause or provision that I didn't comply with and that falls under this general umbrella, which is subsection S. And with respect to that argument, the parties who brought the action did put forward arguments, and what they said is, well, according to this expert report by an expert in cost engineering, I can show you that if at least X, the minimum value of the contract, is not executed, I cannot pay the 2% to the PACMA. There's a link there. What the court said, and I think it said it from the administrative rescission process, is that this expert report on cost engineering is not necessary. What the court said is, I'm not going to take it into account because this is a question that goes to the interpretation of the clauses of a contract, and I am a legal expert. Therefore, I don't have to take into account the expert's answers regarding how one interprets a given clause or annex to this particular contract. When you dismiss that evidence with respect to the PACMA, and I repeat, this also left the moving party defenseless because there's no other evidence that it can present as to why it did not comply with the PACMA obligation insofar as it did not know, this is in its interpretation. I'm not saying I agree or I don't agree, but they tried to show that if I don't reach a certain amount in relation to the contract, then the PACMA mechanism cannot be activated. And the only way to look into this was to have an expert report, because there had not been hardly any documentation in this regard. It was the first time this was going to be used, nor had there been any requirement on the part of the authorities regarding compliance with the PACMA obligation. It was something new. The only way that occurred to the company to show this link, and therefore its argument with respect to compliance with the PACMA, was the expert report on cost engineering. If the court says no, because you are interpreting the clauses of a contract with an expert, which for me is not sufficient reason to dismiss the evidence, then you have no evidence to present to me, and therefore I decree that rescission of the contract is valid on the ground of having breached the obligation with respect to the PACMA as well.
I don't know whether you have, because at some point we'll have to make a break for the benefit of the stenographers. Could we finish just 2 questions, or shall we break now?
I think you better do.
Could you go on for, say, 15 more minutes? Yes, okay.
Are you sure it will be only 15? Yeah, I think it's more because the parties still can ask questions as well. So it's up to you. But
no, of course, later on they will
first.
have to ask questions. Definitely, both. I think there will be plenty of might be plenty of questions. The question is, shall we then make a 15-minute break? Probably the ideal would be to finish.
Lunch break.
To finish with the 2 experts before lunch, and after lunch. So we make now. Do you agree with a 15-minute break now, and then we continue with all the questions for these 2 experts before lunch, even if we have a late lunch, and then after lunch we
I am sorry to insist a bit, but I think it was agreed that the parties could go on. They have given up with cross.
Yes.
But I am afraid that it will be more than 15. That we will have more than 15 minutes.
No, definitely. Definitely. I'm sure there will be many questions from the party. So overall, it will be more than 50 minutes. The question is whether we make a break now, and then from the resumption after lunch, we probably the most practical things will be to stop now for 15 minutes until 1:45, and then we take as much time as necessary to finish both the tribunal and the parties before lunch.
So do a quick break now, then you finish off your questions.
I finish up the parties.
Lunch, and
yes.
Then lunch, and then the parties ask, or the parties ask before we break for lunch.
Well, let's wait. It will depend on how eloquent Mr. Amezquita is in his responses to the 2 questions that I have left. So we'll see. So for the time being, we stop for 15 minutes, and we'll resume at 1:45.
You take in mind.
So we will make a break now for 15 minutes, and then we'll resume at 1:45.